and we'll just get started on today's hearing. Can everybody who's taken part in the hearing, you've all got your cameras on, if it could ask you to keep yourself on mute for now, please. Can I check that you can all hear me? If you could give me a wave if you can. Everybody, that's good, thank you. Okay, welcome everyone to this hearing session in relation to... Now, Mr. Pritchett seems to have frozen, or he's trying to get my attention. Can you hear me, Mr. Pritchett?
Yes.
Yeah, you'd frozen there with your hand up, but that seems to be fine now. So yes, this is the appeal reference PPA-270-2266 for a proposal by Aberdeen Standard Investments for a mixed-use development on land adjacent to Inshes Retail Park, which we'll refer to as Dell of Inshes during proceedings. An appeal was submitted to Scottish Government's Planning Environmental Appeals. This is that. No, I'm not sure whether that's a... just one moment and I will go and check whether that's a drill or not.
They've got it all on mute. They're all on mute. See, all of them are on mute.
Been flying back from back.
Right, well, you'll be glad to know that that is a test that they didn't tell me about. I'm in the offices in Falkirk today, so all is good. We're not going up in flames. So yes, the appeal was submitted to the Scottish Government's Planning Environmental Appeals Division, known as the DPA, following the refusal of planning permission by Highland Council. So we'll start with some introductions. My name's Alison Kirkwood and I'm the DPA reporter who's been appointed by Scottish ministers to determine the appeal. Mr. Pritchett, can you please introduce yourself and the rest of the appellants team?
Morning, I'm Phil Pritchett. I'm the appellant planning consultant and I'm accompanied by Craig Latto, who is the transport consultant, Brian Kelly from Aberdeen and Robert Lewis in attendance as well, but they're not taking part in the hearing.
Okay, could everybody hear Mr. Pritchett? Your sound was slightly lower than perhaps is comfortable. Is everybody else able to hear?
Happy or not?
Okay, thank you. I take it I will address planning matters to yourself, Mr. Pritchett, and transport to Mr. Latto.
Yes.
Mr. Kelly and Mr. Lewis, welcome. If during proceedings you'll be able to switch your camera off as well as your mic if you're just observing. Okay, Mr. Whelan, can you introduce the council's team, please?
Yes, good morning. My name's Peter Whelan. I'm a principal planner within the Highland Council Strategic Projects team, and I'm accompanied today by Transport Planning, and that's Mark Clough, and also Gary Smith as well. He's in the Council's Roads team.
Okay, thank you for that. Obviously, I'll address planning questions to yourself. Any preference in terms of transport matters, or will Mr. Smith and Mr. Clough be doing it as a bit of a double act?
I think they'll divide it between themselves, but Mark Clough covers mostly planning, transport policy matters, and Gary is more the technical brain, if you like, the engineer behind the Phase 2 works for the Highland Council.
Okay, well, hopefully between us all, we'll work out who to direct what to. And finally, we have a third party with us. It's Mr. Gordon, who's a local resident, and also on the call we have Mr. McIntyre, who's been assisting Mr. Gordon. Would you like to introduce yourself, Mr. McIntyre?
Yes, my name's Peter McIntyre. I'm assisting Mr. Gordon. So Mr. Gordon is on camera at the moment, so he can speak now.
Good morning, Mr. Gordon.
Good morning. I'm Murdo Gordon on behalf of my community in the Inshes area, wish to speak and give an oath. I will tell the whole truth, but nothing but the truth. So help me God in any evidence I give.
Okay, thank you, Mr. Gordon. You'll get an opportunity throughout proceedings to give your views on the matters that were covered within your representation. As I hopefully you'll find the proceedings worthwhile. Okay, we'll move on. The hearing will be webcast live by the DPA. The video recording will be retained on the website after the application is determined. By taking part in the hearing, you are consenting to being filmed and to the use and storage of those images and sound recordings and any information contained in them for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. Is that okay for everyone? Callum from our IT team, who you've all met, will be keeping an eye on proceedings today and can provide support if we have any technical difficulties. During the hearing, please keep yourself on mute unless you're answering a question or need to get my attention. This avoids sound interference. If you need to speak to me at any time, just raise your hand or speak out if I don't notice raised hand, if I'm taking notes or I'm not picking you up. The purpose and format of the hearing. The appeal has been determined under the provisions of the Town and Country Planning Appeals Scotland Regulations 2013. Having considered the appeal proposal, the documents submitted with it, and the subsequent exchanges, I've decided to hold this hearing session in order to assist my consideration of the appeal. The procedure notice issued on the 1st of November for the hearing session set out the matters that will be considered today. These are known as the specified matters, and in this instance, they relate to the wording of conditions and the need for developer contributions, should I be minded to grant planning permission. I would stress that the fact that we're discussing these matters does not mean that I've already reached a conclusion that planning permission should be granted. Furthermore, where adverse impacts of development cannot be satisfactorily addressed through conditions or development contributions, this may result in me reaching a conclusion that planning permission should be refused. There are 5 specified matters to be considered at the hearing. They're the approval or otherwise of the illustrative master plan and implications for conditions. Secondly, the Inshes Junction Improvements Project. Thirdly, developer contributions towards wider transport infrastructure and improvements. Fourthly, suggested condition 6 on allotments. And finally, the duration of permission. Now, the procedure notice also explained that no other matters relevant to the appeal would be considered at the hearing. I must stress I will be taking account of all these other matters and all of the written representations that have been received, as well as the various statements and documents that have been lodged. However, I'm satisfied that I have enough information on these, and so we don't need to discuss them today. Mr. Gordon, this would apply to the other matters that you've raised in your representation. Okay, so I'd now like to explain today's sequence of events. For those of you who haven't been involved in hearings before, they are a way of allowing each of you to put forward your point of view while also letting me get the information I need to reach my decision. The hearing procedure is set out in Circular 4/2013, which indicates that the format will be a discussion, which I will lead. The points on which I require further information are listed in the agenda, which was circulated to you by letter and email on the 5th of December. Does everyone have a copy of that? Mr. Gordon, have you got a copy of the agenda? I think that's a yes, thank you. Throughout the hearing, I will invite participants to contribute at appropriate times and give each of you the opportunity to comment and ask questions. And just reiterate that those that are observing proceedings cannot ask or answer questions. Please also bear in mind that I will be taking notes, and my ability to do so will be inhibited by the speed and nature of any exchange. Interruptions or speaking over someone's not acceptable. Discussion must at all times be conducted in an orderly manner. You'll all have a chance to comment and to ask questions, provided those questions are relevant. But I will discourage repetitive or irrelevant questions. Any questions that you want to ask of other parties should be directed through me. The procedure is informal. There'll be no cross-examination of witnesses. I will give you the opportunity to summarise your position on the matters discussed today in the equivalent of a written closing submission after the hearing is over. We can discuss timescales of this at the end of the hearing. I have already seen the site and visited the surrounding area. I don't envisage that a second site inspection will be necessary, but I'll confirm that after I've heard today's evidence. I've assumed that the hearing will last 3 to 4 hours, and certainly no longer than today. We'll take a break this morning, probably after matter 1, and then take stock as to whether or not we need to factor in a lunch break or whether we can just keep going to get it finished before lunch. If anyone needs to pause the hearing at any time, please let me know. And finally, a few housekeeping matters. Parties should use their microphones, making sure to turn them off every time you conclude speaking. This is required to allow the recording to switch to the person that's speaking. It's important that those participating, including myself, have time to follow the evidence and to access any documents the parties want me to refer to. So pauses may be required to allow us to find our place in relevant documents. Is everyone clear about the proceedings? Does anyone have any questions about them or any matters they want to raise before we get started? Are we all fine? Okay, on that basis, we will turn to the first matter on the agenda.
Take the cursor away. Take the cursor away.
Pardon?
Take the cursor away.
Keep the what?
Take the cursor away.
That's it, you're back on mute. Thank you, Mr. Gordon. It'll come naturally to you. By the end of today, you'll be a whiz kid on turning yourself on and off. And you'll find that all of us try to speak when we're on mute. It's a very common occurrence on these meetings that everybody is on mute at some point. So don't worry about it. Okay, so matter 1 that I would like to cover today relates to the approval or otherwise of the illustrative master plan and the implications for conditions. You'll see on the agenda that I've noted a few points that I just want to seek some clarification on following some of the matters that were raised in your hearing statements. So if we could run through those. The first one, really, what I have noticed on the decision letter for the previous appeal listed a number of drawings, not all of which that have been included in the current proposal. So looking at our system, I have that the appeal proposal includes document 4, the location plan, document 7, the illustrative landscape layout, document 8, illustrative master plan, 9 illustrative site levels, and then 10, 11 to 12, which are illustrative site sections. In the procedure notice of 1st of November, I sought clarification from the appellant as to which of the drawings it's seeking approval for. I don't think I got a clear answer on that, so I really just wanted to start with that sort of factual. We'll come on to discussion about the illustrative master plan as there's some other matters, but Mr. Pritchard, perhaps you could clarify, is it only document 4, the location plan, that the appellant is seeking approval for through this permission?
Through this appeal process, we were originally happy with just the location plan being approved. However, having gone through the proposed conditions and in particular the council's response regarding location of buildings and then the flooding issues and transportation issues and other more detailed matters, we've actually now lodged quite a great deal of supporting information, which leads us to the view that actually the master plan that is illustrative is actually the plan which is for the appellant the optimum overall site layout which is deliverable, and that includes the site access, the issues relating to flooding and culverting, site levels and flood levels. And so because that was the plan that had previously been looked at, and we always were of the view that the council would be generally supportive, and we recognise it's not, you know, absolutely in detail what would be approved originally at the end of the day, we thought it might be helpful if the plan that we lodged under our email of 12th September, which is 002B, it might be helpful if there was a reference to that plan as being generally supportive. But we leave that for you reporters to whether you think that's appropriate or not based on the evidence.
Okay, I mean, my understanding is there's a slight difference between your suggested wording that that it would be approved subject or based on the illustrative master plan, and this actually being an approved stamped drawing. So I think I understand what you're saying about including reference to it in a condition. I think that's slightly different than it being put forward as an approved drawing. So we can come on to the wording of the condition. Just for Mr. Gordon, this is the drawing that we're referring to. So it's document 8, I think, in the submitted drawings. Mr. Whelan, do you have a view on that from the council's point of view?
Yeah, no, thanks for bringing me in. I've had a good look at the information that was submitted with the appeal last time round and what was resubmitted this time round in terms of the renewal. Going back through the history of it, it appears that the illustrative master plan with no revision on it showed a roundabout access. So when the application was initially received, before the last appeal was determined, there was a roundabout access showing to serve the site. During the course of the last appeal, that was then revised with revision B, which then shows a T-junction arrangement. Both were lodged during the initial 2013 application, but it was only revision B showing the T-junction, which was the one which was listed in the last appeal decision drawings. And then in terms of what we consider to be the best position for the council moving forward would be for that roundabout layout, showing a high capacity solution to access this site, but also serve the petrol station, the Tesco, would be the preferred solution. So not the one showing the T-junction, but the one showing the roundabout would be our preference. But I have to accept that it is illustrative, so things do change, and there has to be scope within the wording of any condition moving forward to allow for adjustment. Because neither of those access solutions aligns with the council's phase 2 works for the Inshes corridor. There are differences between those two, namely that there is no connection showing to access Culloden Road. And that is critical, as we see it, to the mitigation measures which are necessary to serve this site. So the drawing which was referenced in the last appeal decision, it does show an indicative access solution onto Caulfield Road is the SK004 Rev 1 drawing. And that's entitled Indicative Phased Site Access Option Amended, and that's referred to in one of the conditions of the last appeal. So in terms of the council's position, we're looking for... Sorry.
I don't think I have that document as part of this appeal. I know it was something that the appellant was suggested could be lodged at this stage, but I've gone back through the documents that I have, and it's not a document that I think I have before me at the minute. I know it was referenced in one of the conditions on the existing permission, but it would be difficult for me to reference a document in this permission if it wasn't submitted as part of the application.
Appreciate that. So if it's not been lodged, and you can't then therefore make reference to it, our preference would be for a condition that approves only the location plan and has a reference to the requirement for a finalised master plan to be taken forward. And you could perhaps look at the wording of that condition to require a direct access to serve the site off Culloden Road instead of referring to a specific drawing.
We'll come on to the wording of a condition. I think just that first point was just to clarify what the what each party's position was in terms of the approval of the documents, not just the illustrative master plan. So it was just making sure that I was clear in my mind. I'll come back to you and let you in, Mr. Pitchett, that what the appellant is asking approval for. So I think it's definitely the location plan. There seems to be a mixed view on the illustrative master plan. Can you confirm, Mr. Pritchard, you're not seeking approval of any of those other drawings?
No. We accept the plans are illustrative, but I think just very briefly, the reason why the T-junction was favoured was for accessibility reasons, because that is the way in which pedestrians and cyclists can access the site properly. And Gary will recall in very early discussions regarding the Inshes Phase 2 works and everything else, it was the council that was debating whether to have a roundabout or a T-junction. The up-to-date position is, and I think the papers in this appeal stated, is that we only have support on flooding issues for a T-junction because of the length of the culvert. And so you do have in the papers on our email of the 12th of September, we lodged 002B, which is the illustrative master plan, which was referred to by the reporter in the previous appeal decision. And as I said, that is the plan which deals with all of these technical issues to the best of our ability at this time, and dealt with all of the, obviously one of the reasons for refusal was flooding. We've now hopefully overcome that issue, but that is based on the T-junction. Now, we fully accept that the council may want to do other junction arrangements and access Tesco and Culloden Road, but for the purposes of this appeal, it is only really the T-junction that we are able to suggest to you can be supported primarily because of flooding issues.
Okay, thank you for that. I'm aware of the flooding issues. Obviously, in my first procedure notice when I got written submissions, and I sought the views of SEPA on the issue of there being the two different access arrangements that were shown. So I think I'm comfortable that I've got the information that I need on that. I think what we're trying to resolve today is obviously the challenges of a planning permission in principle, when there aren't firm proposals, and trying to ensure that if planning permission is granted, that both the proposal can take place, but that it doesn't prejudice the wider transport improvements, which is quite a challenge whenever there are unknowns, and I appreciate that. And but your input and your thoughts are helpful. So say we will go on to some of the implications of some of this, but could you clarify, Mr. Pritchard, just the very factual things? You're not seeking approval of those other documents. That's all I'm trying to establish at this matter 1A. We've a lot further to go, and we'll go on to that. But I just want to be clear in my mind that that I understand what the appellant's point of view is. Mr. Gordon, do you want to say anything on that matter in relation to the illustrative master plan? You want to comment on that?
Slightly, just about the T-junction arrangement, and regarding the flooding, as you confirmed there. Potentially, none of these solutions, either a T-junction or the roundabout, would improve anything overall throughout the whole network.
Okay, thank you for that. I've noted. No. Okay, we'll move on from that first matter if that's okay. I'm going to suggest that we take items B and C on the 1B and C on the agenda together. In preparing for today, I found that there was a lot of overlap from it, so I think it's possibly easier if we can take those both together. One of the options, if the submitted illustrative master plan is not approved at this stage, I sought views on a condition which would require the submission and approval of a master plan for the site prior to the submission of detailed proposals. Now, I think I understand that that's the council, from what you said, Mr. Whelan, that would be your preference. In response, in paragraph 1.2 of the appellant's hearing statement, the appellant suggested the inclusion of a clause which would state that this future master plan should generally accord with the illustrative master plan submitted. So this is the difference, Mr. Pritchett, where the illustrative master plan wouldn't necessarily be approved at this stage, but you're seeking to recognise give some status to it as a indicative way forward. Mr. William, the views of the council on that? Have you given that some thought?
Yes, I have, and I have read what Mr. Pritchett said as well in his statement there. So, in terms of the wording that we would look for, we would like to include specifically the words, if there is a reference to any indicative master plan, except as otherwise provided for and amended by the terms of this approval. The reason why those words are very important, as Mr. Pritchett points out in his statement, is without those words, that will then render the more detailed restrictive conditions irrelevant. So what we don't want to have is a situation where we've got an indicative master plan referenced that trumps any of the other conditions of the consent.
Can I just ask you again, except as otherwise, what was the
except as otherwise provided for and amended by the terms of this approval.
Thank you. Mr. Pritchett, do you have any views on that further clause?
Well, I think we're going to come on to this in some of the other questions, because the whole purpose of this exercise is to provide confidence to the appellant that this development approved in principle can be built. And what we're trying to say in our appeal submissions is we have to juggle all of the technical matters, which we're trying to do, and also the retail market matters, and produce a viable scheme. And we know, having built out the south end of Inshes Retail Park, what the market will consider to be viable. I think we're saying we are accepting that this is a generality, but what we can't accept is something that, from the council's point of view, provides us with such restrictions that makes the scheme unviable. And that's just what we're concerned about. Is, for instance, where the buildings are positioned is absolutely crucial for viability. If, as we'll come to, the conditions later on are varied or deleted, then I don't have a difficulty in suggesting that there is reference to further conditions. But as I say, we just can't have conditions that make the scheme unviable.
Okay, that's helpful, and I can understand. Yes, we need to discuss the details in the conditions, because that's where the cross referral would come to. So, do you want to come back on that, Mr. Whelan?
No, I'm happy to part the conversation for individual conditions and have them addressed at that stage. The only other reference that I wanted to be clear about was what they've actually applied for in terms of the permission. So, including the amount of floor space proposed, the mix of uses proposed. I just wanted to check with yourself if your intention was to include that within the condition as well.
We'll come on to that when our discussion's under condition 1, because I think that's the one that the council has suggested, which is very prescriptive in terms of the floor space, which the appellant has commented on. So I am quite keen to explore parties' views on that a bit further, and I've had some thoughts as well, which perhaps seek your views on. But I think I understand that's helpful in terms of that kind of the clause. The second part was a question I put in the procedure notice on the hearing statement, which was supposed to think through an alternative approach to if there is a condition which requires a further master plan, is it enough just to say a further master plan, or there's obviously suggestions in terms of alternative of clauses to add to that. What I was thinking was, would it be helpful, again, I suppose, to give certainty to both the council and the appellant to indicate what the council's expectations were in terms of that master plan. So obviously the appellant's expectation is that it would be based on the indicative illustrative master plan, but it was whether are there particular things that the council would be looking for to be within that master plan, and that's where, as you know, it suggested, I suppose the key things were that it didn't prejudice the implementation of the Inshes junction improvement, and that it addressed some of the requirements from the Inshes and Ragmore development brief. And the council came back in paragraph 3.4 of its hearing statement. Well, you've got that in front of you. I can read it out. It said was that any master plan must demonstrate how the development will help facilitate safe, active travel connections, particularly to and from the adjacent commercial centre, and deliver enhanced strategic road capacity in this part of the city, including safeguarding land and enabling the delivery of the Inshes Junction Improvements Phase 2. And then the kind of the catch-all, accordance with all other planning conditions attached to the planning permission. So I think I understand the context from the council's point of view of the reasoning behind those additional clauses. Mr. Pritchett, have you got any comments on that, the council's response on that? Would that cause difficulty to the appellant?
I think it doesn't provide certainty. I think, as you'll probably have gathered from the long history of this development, we've not got to a point where these issues have been able to be resolved with the council. We think we've always put forward a proposal which is capable of of being granted planning permission in principle, which deals with the technical issues on the site, there is clearly a difference of opinion between us and the council as to how a planning permission should be formed in its conditions and what we can then take forward through for detailed matters. I think our concern with adding such prescriptive details into a planning permission in principle is that we are then in a position whereby we don't have any certainty that we can just put in matters specified and be approved. We would be dealing again almost with matters of principle, which I think we've always been grappling with over the last decade or so. So that's our difficulty. And there's just a difference of opinion, which I think, frankly, we're looking for your guidance on, is to, we just think we've done so much work on the illustrative master plan indicative, which we think is capable of being developed and could be generally referred to in conditions, and allowing us to lodge then those matters specified. And the other conditions also allow us to deal with off-site roadworks, because I think, and this again is our difficulty and the difficulty that we've been grappling with again for a long time, and to be fair, the council has, is there is still no certainty that major off-site roadworks are going to be delivered. We all hope it will be, but there's no certainty, and we just want to crack on and build the site out with conditions that can be properly fulfilled by the appellant. So that's our position. I think we go too far in the council's suggestions on this, which I think would be pretty much back to square one is our concern.
Okay, that's helpful to know. I appreciate both parties have been involved in this for a long time, and I'm coming to it relatively fresh. But I can certainly understand the challenges in terms of a planning permission in principle where there is uncertainty, and that's what I have to grapple with, and that's why I wanted to hold a hearing rather than to try and resolve this through written submissions, because there's a lot of issues going on, I think, which everybody appreciates. So I think what today will be about bringing together all of this, and then I'll go away and think further. But it's really helpful for me to understand where the concerns are and where the opportunities to resolve these matters sit. Does that sound okay? Mr. Gordon, have you got any views on this matter in terms of how much should, if planning permission in principle is granted, how much should be approved at this stage? Or
I will just refer to obviously what I've heard just now of the evidence. Between the public inquiry and today's evidence, there is still inconsistency. If even the conditions will improve things, when we all know it won't. In other words, there will be further mitigation onto the works, to the site and surrounding proposed. We know the problems already exist. So, therefore, the whole networks and the problems of that associated with further development. So the conditions, I hope that, and you crave, through you and the reporters unit at large, will impose further restrictions as we go along.
Thank you for that. Mr. Whelan, you want to come back in on that?
Yeah, if it's okay, I'll take the opportunity to bring my colleague Gary Smith, who's been working on the phase 2 scheme, and he can maybe talk through some of his engagements and what his observations are between the master plan and the phase 2 works, if that's helpful at this point.
Perhaps I'll leave that, because I think once we get into the details of that. I'd rather leave that till item 2 of the agenda if that's okay, because I think we need to explore in detail a lot of that matters. Mr. Smith, that's okay. We'll hold your input until the next matter. I know there is a lot of overlap, and it's difficult to divide things up into different sections. But I have a feeling that once we get into that, we'll get into the real nitty-gritty of it, and I'm not sure I want to do that at this stage.
No, that's fine. I was just thinking about the integration of active travel movements between the commercial centre and this development site. So.
Okay, well, I'll take a note to make sure that we cover active travel when we discuss the improvements. So if I don't, please remind me.
Thank you.
Mr. Pritchett.
Yes, thank you. And it's really just in response to Mr. Gordon, and I think this has been a long-running theme throughout this process and previous processes, is we've always taken the view that where we can help the council, clearly the appellant will do because of the landholding that Aberdeen have. But I think where we've always had a difficulty is all we've been seeking is trying to be granted planning permission. And we've always taken the view that our ability to be granted planning permission is not on creating betterment in the road network and what the council and others may want to do for reasons that the council needs to do in terms of the proper planning of the area and the expansion of Inverness and roadworks, etc. What we've been trying to grapple with is how can we be granted planning permission to make sure we do not make anything worse? And I think that's been our difficulty, and I don't know whether it's come through from the papers, but we're delighted to help out where we can, but we do not think that our reasoning for being granted planning permission should be confused with the council and others trying to make the roadworks better around here. That's where I think the differences lie in this whole process. So that was just in relation to Mr. Gordon's quite legitimate concerns. But we don't think we're there to deliver these things. We're there to be hopefully granted planning permission based on the proper planning assessment and the development plan and material considerations, etc.
Thank you, Mr. Pritchett. Yes, that's helpful. Mr. Gordon, in terms of when development is granted planning permission, there are restrictions in legislation in terms of what conditions and development contributions can address, and it needs to be where it's necessary to mitigate the impact of development. So Mr. Pritchett's correct in terms of pointing out that it's not the purpose of a development to make things better. It's to make sure that it mitigates any impact that it has on the system. And we'll certainly be coming on to that whenever we look at the proposals for the improvement junction and the request for development contributions for the wider network. But that's the context. There's circulars and there's legislation that we need to work within. But your point is well made. Thank you. Just check where we're at under items B and C. When I suggested the inclusion of such a condition to, I suppose, require the submission of a master plan before the details came in, my question was whether that would remove the need for some more prescriptive elements in some of this council's suggested conditions that the appellant had concerns of, and this is where we get the overlap. For example, conditions 7, 8 and 17, and I'm seeking to explore whether some of those matters in terms of the layout of the site and the active travel and the safeguarding for the roads improvements, whether they could be addressed through the submission and approval of a master plan before the details came in, which would perhaps wouldn't need that very prescriptive wording in a planning permission in principle. So I think the only way that we can do this is to go through some of those conditions and just try and tease out where the differences of opinion lie in terms of where these are heading. I think we need to look at condition 1, 7, 8 and 17. And these would be the revised versions that are in the council's hearing statement. So it's probably helpful if everybody has the council's hearing statement, just so we have the starting point, which is the council's suggested wording. Does that sound okay as a basis for looking at these? So first of all, condition 1, which is in paragraph 3.2 of the council's hearing statement. This is the one where we're saying planning permission in principle is hereby granted for a maximum of 4,700 square meters of gross floor area, comprising the different classes, presented as one large unit of 3,252 square meters and 8 smaller units of over 1,441 square meters, and then goes on to list the other ancillary elements and the access roads, all to be carried out in accordance with an approved master plan. Mr. Pritchett, you indicated that the appellant feels that that's too restrictive at this stage for a planning permission in principle. Do you want to elaborate on that?
Yes, the appellant doesn't have a difficulty with the figures because there are figures, and that's what retail and transportation assessments have been based on, and it's been shown that that scale of floor space can be delivered on the site. So clearly we're happy with reference to the maxima. So we're quite happy for a condition to say this is the maximum amount of floor space within those use classes that will be granted planning permission. I think that where we get into difficulties is prescribing there shall be a number of units, and I think that's, I think as Mr. Whelan has said, that this at the moment is clearly not a specific development for operators because we can't market the site yet because we don't have planning permission. So I think to be so prescriptive in terms of numbers of units is going to be restrictive to the appellant in the marketplace, because whilst we anticipate that general layout plan is something that the market will approve of, we can't guarantee that precisely those numbers of units will be delivered. And we think that, subject to other conditions that we can go on to regarding subdivision, etc., we just think that the maxima is something that can clearly be accepted, but the layout numbers of units would come out through the master plan and through the matter specified, and we think that that's sufficient at this stage to safeguard everything that the council wants to safeguard, but also allows the appellant to go to the marketplace and actually get these retailers and operators interested and come forward with detailed plans.
I just come back to clarify, because I suppose what I'm perhaps struggling with is on one hand, the evidence of the views of the appellant is that you want the illustrative master plan. That's the layout that you want to put forward. But then in relation to this matter, you're saying, well, it's not necessarily the layout that we want. Can you see what I'm sort of I'm grappling with?
We think at the moment that there will be the neighbourhood units, the smaller units, and there will be larger scale users. Whether that's one user, it could be. You know, we've lodged within the documents agency support here from the retail market that says there are big box users interested in the site. Whether they specifically will want that amount of floor space and the configuration, and that's why we, quite happy to still use the word indicative and generally, but we can't at this precise moment say exactly what the configuration will be. And even in the neighbourhood units, I mean, for instance, I've been doing ones recently in Cooper where we've got a range of units of 100 square meters up to 400 square meters, and 8 units could become 6 units. We don't think that that would necessarily cause a difficulty to the council, and it gives us sufficient flexibility to encourage occupiers to come forward, but generally within the scheme that we've lodged. We think that's deliverable, but being too prescriptive means that we continually have to go back and seek support for changes when we're trying to market the site with a planning permission in principle that's deliverable.
Mr. Whelan, I'll let you comment in a minute. I suppose the two things that I want to come back from the maximum floor space I get. I suppose one of the questions that I asked in my written procedure notice was considering the implications of reconfiguring that floor space in terms of potential impact on the city centre and compliance with the brief, which is talking about a sort of a retail development to serve a neighbourhood. So I can see that the neighbourhood units, trying to understand the importance of the neighbourhood units in terms of meeting the requirements of the development plan and the supplementary guidance, but also understanding if that was a larger unit, the single big box, as you call it, if there was more than one big box, would that have more of an impact on the city centre than the retail assessment has addressed? Mr. Pritchard, do you want to come back on that, and then I'll bring in Mr. Whelan?
There's clearly a difference of opinion because of the reasons for refusal in terms of retail impact. I mean, our evidence is clear in that I know that there is a view that this is a large-scale development by the council, from the council's point of view, but in terms of impact, I mean, the only evidence before you is that the maximum impact on any recognised centre is less than 3%. We fully understand that councils are concerned about retail impact, but the whole basis of this planning application going back many, many years was that actually in these district centres there was a need for more floor space. This appellant has developed out all of Inshes Retail Park, and there was scope for more, and there always has been scope for more. And so therefore we were of the view that impact on the city centre was not previously raised as a reason for refusal. We don't think that variations within the maximum floor space that we've applied for, we accept that the council want to know what's going to happen in the fullness of time, and we're here to discuss what those restrictions can be. And quite happy to have this debate today about what parameters we need to sit within the conditions. And I think if it's too restrictive at this stage, we can't even go to the marketplace to say to retailers, we can deliver a planning, a planning consent for you if it prescribes precisely what these units have to be, when we don't have the occupiers at the moment. And we didn't have the occupiers in Southern Inshes Retail Park when we were granted a consent for 10,000 square meters. So double this floor space was granted at the southern end of the retail park in 2017. And we built out the Dunelm, the B&M, and then what became the Costa and the McDonald's. But originally, that was going to be B&Q. So these things change, but none of that, I don't think, has been of a concern to the council. It's just that's the way in which the planning permission processes work. We need this planning permission to be deliverable, and so then we can go to the marketplace and find those retailers and come back with the matter specified.
Okay, thank you. I would like to try and explore potential parameters, but I'll bring on Mr. Whelan first of all. Do you want to respond to anything that that Mr. Pritchard has said and indicate the council's view on? Obviously, we've got your suggested condition. Is there scope for it to be slightly less restrictive?
I think there's scope for discussion. I think there's a couple of points we just might put down, if that's okay. I don't want to get into the whole reasons for refusal under retail impact grounds, but if we have to stomach an extension to this retail park because it isn't in the retail park at the moment, there's a clear defined boundary within the development plan that sits without that. If we're going to have an out of centre development such as this renewed, we would like the terms of that renewal to be very clear and precise over how much floor space we're talking about and how much has been assessed. The division of that floor space and the wording set out in the condition does reflect what the applicant has applied for in terms of the indicative layout. And in order for them to market the site, I appreciate they will have difficulties given that they have no end user identified. It's a speculative development. The importance of having the 8 smaller units is to accord with the principles of the development brief, to bring in small occupiers, local occupiers, to provide a neighbourhoods function. The difference is by having the large unit on half the master plan, which derives a national or a regional retailer, clearly doesn't sit neatly with the development brief for this area or the allocation within the development plan. So the principle of subdivision of the 8 units into, say, 4 units does cause concern, because you could bring in larger retailers who are demanding more floor space, and therefore they could relocate from the city centre or choose to locate in this extended retail park rather than within the city centre. So in terms of keeping the unit sizes small for that aspect, that is definitely the council's preference, to limit the impact in terms of retail impact on the city centre. But in terms of subdivision of the larger unit, I think that's open to debate. Because the further subdivision of the larger unit may or may not be beneficial in terms of overall retail impact. And it offers Mr. Pritchard a little bit of flexibility in terms of who they market the biggest unit to, and if they wish to divide that across 2 potential retailers, for example. But all of this could be addressed under the terms of a full application, with planning permission in principle, if they choose to deviate from the wording which is set in the condition. So there's ways and means of changing it, but then triggers the need for reassessment.
Okay, thank you. Obviously, we have an application, we have an appeal before us, and it's for planning permission in principle. So that's what's the scope of my considerations. One of the I think options that I'd like to explore is whether, in terms of a limit, that that you could introduce a sort of a bit of flexibility, which would still cover the council's concerns. If there was, if the condition restricted the size of the larger unit to a maximum of 3,252 square metres gross, so that wouldn't be as prescriptive as the council has suggested, but it would mean that the larger unit wouldn't become any bigger than what has been covered in the retail assessment. Would that work in terms of that element of the proposal? Obviously, I need to take a view as to whether or not 3,252 would have an impact on the city centre. But if I felt that one larger unit would be acceptable in terms of that, if it was restricted to not being any larger than that, would that work for the appellant, Mr. Pritchett?
I think we've always accepted that because that, I know it's very difficult. Our layout, as it were, which we're, have always put forward, has always assumed that that unit would be a maximum of that size. I think our difficulty is what we've said is there may be a user that will take that size. What I've had in the past with retail parks throughout the UK is the total maximum square footage would be this. And you could also have, and I've had this, I think in Highland and also other councils in Scotland, is a minimum size. Now, I don't know whether Peter's view would be a minimum size would also be appropriate, and that's normally 929 square metres. And that caters for an awful lot of retailers. I'm not saying that, and I haven't taken instruction on this, but that's sometimes, so you would have a minimum and a maximum. So obviously quite happy with the maximum being one unit at 3,252 square metres. If there is a concern about, huge amounts of subdivision and complete change with that, I have definitely in the past accepted on many retail parks a minimum size of something like the old school 10,000 square feet or 99 square metres or something like that. And that then gives more definition to it and means that we don't need to go back every time to say, oh, we've got such and such, can we do this? And then similarly with, as I say, with the neighbourhood units, I know because I've just finished 2 or 3 of these for other clients, is they're normally between 100 square metres up to 400 square metres. So again, if there's a range within the neighbourhood units, I don't want to go down a line where we're getting so prescriptive that we're looking at such fine details, but I do understand Peter's, view in terms of they want to know what this thing is, and so do we, but we've got to allow the marketplace and the retailers to be able to see the scheme and know they can fit within it. We are putting forward this proposal knowing that there are operators out there, but we simply can't take that any further forward because we don't have a deliverable scheme at the moment, and that's what we're just trying to achieve.
From my point of view, I think it's less about knowing what's going to happen. It's about ensuring that's what's been assessed in relation to the requirements of the development plan policies. So as I said before, it's is there a restriction that would work better in terms of impact on the city centre, and in terms of the smaller units, I certainly consider that there should be a minimum amount of floor space that's allocated to neighbourhood units, and perhaps a minimum number of units. Now, there's 8 in the layout. I can understand that it might be that 8 doesn't, that there isn't demand. You can't make 8 work. But is there, maybe the council could come in, that is there a minimum number of units that would still meet the aspirations of the development brief that would allow a development that does provide for the local area? So I say it's less about being prescriptive in terms of what the development is going to work out, because I fully understand that there will be twists and tails, and what becomes the first operators of a development may not be the second and third, and developments will evolve, but it's assessing it against what the requirements of the development plan is my first consideration, and I'm trying to, I suppose, to understand if conditions are needed to better fit, to ensure that it's not so wide open that we're assessing what's before us now, but if the conditions aren't tight enough, then a totally different development could come forward. But I understand if the conditions are too tight, then it doesn't allow for the needs of the market or the needs of the neighbourhood to change. You know, it may be that there are different, that the local area needs different things. So it's a challenge. Nobody's got a crystal ball in terms of what's coming forward. So in terms of the neighbourhood units, Mr. Whelan, I mean, maybe in terms of other examples in Inverness or elsewhere, is there a minimum number of units that you think is 8 the minimum, or is there a range? Would 5, you know, would a minimum floor space across 5 units potentially meet what was the requirements of the development brief? Can you understand where I'm trying to?
Yes, I understand the difficulties here, and I understand the difficulties for Mr. Pritchett as well in terms of marketing the site. So mostly we would be relying upon the applicant's agent to market the site, to attract a retailer, then come forward with a proposal that defines what they're looking for. In this case, they've put together an arrangement that they have sought permission for. And I know at the same time they've been marketing the site for different operators, for example, trying to attract Lidl food store to the site. So if we took Lidl as an example, just now food retail is precluded by the conditions of the appeal permission at the moment. But if we just took them as an example and said, well, if that's 2,000 square meters, if that's the larger retail.
Can I just clarify?
Unit,
you're not seeking food permission in this permission either?
No.
Yeah,
No, this is
that's
the
fine.
renewal
I know
of the
you can
consent.
come in with a future application, but I was beginning to think I'd missed something.
No, we'll have to assess that separately as well, because it has impacts in terms of peak trips on the network. It has a different impact to what has previously been assessed in the transport assessment. So if we take that just as a working example at the moment for the purposes of the discussion, if that was 2,000 square meters and that was your larger retail unit, and you had a residual 1,200 square meters left over, plus you've got your 1,400 odd for the 8 smaller units. In my mind, if you have one large unit, you meeting the requirements for the operator, and the rest of it being put forward for community smaller shops that serve our district, or not a district, a local neighbourhood 20-minute shopping destination function. And I think we need to think about perhaps a maximum floor space within each of those units moving forward, the 8 plus whatever is residual. Now, Phil had mentioned 400 square meters, but I don't know if he can provide evidence of different retailers and what floor space requirements they would have. 400 to me seems still pretty large, but I would like to stick a minimum of 8 units and 1 large unit, and perhaps they could come forward with more smaller units than 8.
Just to be clear, you think that a minimum of 8 is what's needed to provide that neighbourhood function?
I think with 8, there's what I'm saying is, take one big retailer and put it on the site. He's got a big enough envelope that will have residual space left over. And that residual space to fit with the development brief should be put over to smaller uses, smaller operators. So the configuration of the 8 may change from what's in the indicative master plan. But what we want to try and avoid is that we end up in a situation where you have perhaps 1, 2, or 3 large regional operators within the site that haven't been assessed in terms of their impact on the city centre, will have a greater impact on the city centre. So one large operator and the rest divided into smaller. Community uses smaller shops. That's our preference, and perhaps we should have a maximum floor space for each of those smaller shops to fit within that brief.
Okay, I think that's helpful, because I think the wording that the council suggested for condition 1 wouldn't allow for that flexibility. And I suppose that's what I wanted to try and explore today, that, you know, that it seems to be that the council accepts that it could be beneficial all round if there's an element of flexibility to allow different configurations, albeit there should be some parameters because of impact on the city centre and the fulfilling the neighbourhood role with that.
But to be
Yeah,
clear,
okay.
we are still firmly of the reason for refusal is impact on city centre. We don't accept one big retailer on this site, never mind multiple ones. So I think the point
Okay,
being,
it's
if we're
helpful
trying
to
to
have your
limit that
views
impact,
within that context.
yes, that's right. That's precisely that. So it's about what parameter is appropriate to set, and we would need evidence to you know, perhaps look for evidence to see what type of retailers could be occupying those smaller units in terms of what their floor space requirements would be. So you get a feel for, are they operators that would attract people from a large area, or would they be people from a local area that would use those facilities?
Okay, thank you. Mr. Pritchett, do you want to come back on that? And does the appellant have a view in terms of a minimum number of units for that neighbourhood function? And obviously your what you think could work in terms of viability?
I just don't think it would be helpful to be too prescriptive at the planning permission in principle stage. I'm just thinking of one I've just recently done in Cooper, and I think I lodged 4 different iterations of the neighbourhood units because of the operator requirements, and they were all neighbourhood units, but they varied in terms of what their requirements were from class 3 to class 1, and I think 8 is a large number of units. I know we have that on the master plan, but I just think to prescribe that there should be a minimum of 8 units, my own feeling from the ones I've done is that's a lot of units to say you must have that number. And
Do you have a view on what minimum?
I'm trying to think from the appellant's point of view as to, you only build if you have sufficient numbers of operators to go in there, but you would want to build if you have, well, I know from the one I just did recently, once they had 4 operators, they wanted to build because they didn't want to lose the operators. But to go from 4 to 8, that's a huge marketing exercise, and juggling so many operators to come in and get them all at the same time to do it is hard. So I just think I'm trying to get as much flexibility and deliverability for my client as I can. I fully accept what Peter's saying about you want neighbourhood units, and so do we. But I think to say there must be a minimum number, you know, for instance, built, I think is really difficult for the appellant. Size, absolutely. I don't have a difficulty with size, and if there's a minimum size or a maximum size, we can agree to that. But to build a certain number, I think is really tricky to put that on to a developer, because I know getting operators signed up all at once is hard, and then you've got to build it. So I think we should move away from being too prescriptive on how many units you build.
I don't think we can take that much further. I think I understand what both parties' views are on it, and I'll take that away and consider it further. Mr. Gordon's popped out, so I don't think his comments relate to transport, so I don't think he will be looking to comment on that. How are we doing? Do we want to take a break now, or will we bash on for until the end of matter one? How are we feeling?
10 minutes would be
Would
good.
be
I
good.
I'd
Right.
quite like to just speak just to the appellant just to see that I'm on I'm on the right lines at the moment. Thanks.
If you don't come back, we know it's it's not good. Okay, we'll take a 10-minute break. It's nearly 15:15, so we'll come back at 11:25. If you can just stay on camera and just turn your cameras and microphones off. you following things okay, Mr. Gordon? You need to take your mic off mute. Just waiting for a few more people to return. There we go. I think we've got all our participants back. Thank you. So we have a few more matters to look at in relation to conditions before we finish matter one. I don't think we're going to get finished by lunchtime. So I suggest what we do is that we proceed towards 1 o'clock, and when it's a appropriate moment to stop around there, we'll take a break for lunch at 1. If that would be okay. Is everybody available this afternoon? That's helpful. Okay, so the last few matters in relation to conditions. So I think we're on to matter 1E, which is looking at the council's suggested condition 7. Now, initially, in its appeal response, it suggested wording which the appellant commented on in its response to the appeal statement. The council suggested a revised wording. I think part of the concerns was that it wasn't sufficiently precise. The council suggested a revised wording, and this one relates to the layout of the buildings on the site, and then being positioned closer to the west, close to the western site boundary, with active frontages being orientated towards serving customers arriving by foot or by bike, with the majority of car parking situated to the side or the rear, and the reason being given to help reduce private car dependency and facilitate link trips with the adjacent commercial centre. Mr. Pritchett, do you want to comment on that revised wording? You haven't had a chance to come back on that yet.
The positioning of the buildings is absolutely crucial to make the scheme marketable to potential retailers. We know from the development of Southern Inshes Retail Park, which, as I said earlier, the Dunelm, the B&M, the Costa and the McDonald's, is a centrally located car park with buildings around it, is what the development market and the retail market expects and functions as. We can't live in a vacuum whereby at the end of the day these occupiers will go where they are able to function. There are other technical matters, one of which is flooding, and another one is trees and access. The access is from the front of the site. I've had this discussion actually with the Highland Council and with Cairngorms National Park in Aviemore, where we had exactly the same debate about frontages. Our point here is actually, in terms of the area around Inshes, there is no building line, there is no frontage, it's not a high street. the functionality of this retail destination is based around the road access, and whatever as planners we might all want to do, the car parking to the front of these buildings is crucial, particularly where you get servicing for larger buildings. And I think this is it's vital for the operators. The larger units will clearly be accessed for service vehicles with heavy goods vehicles. Having buildings at the front, which means that you service to the rear, and then behind that you have car parking, which will be very remote and peripheral. I mean, people actually walking further if they arrive by car. So I think there's a whole host of issues with the orientation of the site. We think, and this is why it goes back to your first question about a master plan, we think our master plan is deliverable in general terms. The buildings are in the right places, they work with the site levels, the allotments go around the back, the servicing goes around the back, the car parking is at the front, you lose as few trees as possible, the access is a single point of access, flooding issues are dealt with. And we just don't feel as though there is a sound planning reason for changing the way in which the whole of the Inshes retail park has been developed over time. It works and it is deliverable and functions very well. So we just don't see this condition as working at all for the appellant.
Thank you. I'll come to you in a minute, Mr. Whelan. It was just a follow-up question from myself, Mr. Pritchett. Do you consider that an illustrative layout meets what was the reason that the council gave for the condition, which is to help reduce private car dependency and facilitate linked trips to the existing centre? Does that layout work to meet those aims?
We don't think it would do, in that any development requires a certain level of car parking, and we don't think we're over providing. What we think we're doing is providing a necessary level of car parking for the neighbourhood units, for the large units, and for the allotments in a layout which works for everybody. And car dependency depends on how people are travelling around this area. We think that how we have laid out the site, and with all the other conditions which we're not disputing about accessibility, and the way in which people, if they park on this site in a frontage car park with an access junction that we're suggesting could or should be a T-junction, it means they have one place to park and then they can walk between the other areas of the retail park. I think our difficulty is that if people come by car and they're forced to park in this site around the back in a remote area, they're then much more likely to drive to other parts of the retail park. And we just don't think that it's something which is going to be deliverable. And I think our view is we don't think it reduces car trip generation. But could I just quickly pass over to Craig Latto, who's dealt with this issue here and elsewhere, and Craig can maybe just comment on that as well.
Yes, please, Mr. Latto, and then I'll come back to the council.
Yes, thank you. We've dealt with this in
Getting a wee bit of an echo there. Do you want to try again?
Is that better? Yeah, that's done. Yes, we've looked at this at a number of sites, and as Mr. Pritchett said, it's discussed, off and on, depending on the type of development. For retail, there are a number of issues. There's issues if servicing and the public are mixing, then there's potential conflict. You've got operational issues, health and safety issues there. The sort of indicative or illustrative master plan like the rest of the Inshes Retail Park, very much looks at the connectivity between the units, and I'm sure, having been up there, reporter, you'll have noted the existing arrangement of the Inshes Retail Park, of which the southern section was extended. There are designated crossing points, pedestrian cycle routes, and again there are clear active travel routes off Culloden Road and from the south and elsewhere. So the connection between where the car parking is and where the pedestrian routes is a bit of a false argument and discussion point. There is no linkage between the two, and in fact, it creates that open environment. Car parking generally looks to sort of hit minimum standards in terms of inclusion, and you don't want car parking to be isolated. That creates actual and perceived vulnerability and security issues. Very much as Mr. Pritchett's noted, the proposed access. There's also proposed connection to the south across the Burn, and again connections up towards Culloden Road. So very much active travel is at the heart of proposals, and so we don't see the purpose of this, and again the connection to somehow it's going to reduce private car dependency in this development.
Okay, Mr. Whelan, do you want any comments in terms of the necessity of this condition? The other point that I want to clear in my mind is kind of the implications of this in terms of the need to safeguard land for the Inshes Junction improvement, which obviously would take land at the western part of the site. So I was sort of trying to envisage what the wording of that condition would mean for the other uncertainties that are still in the game.
It's a very good point. I think the key thing is to look at the history of the area and to look at the commercial centre and how it was expanded. So if you look at the southern extension that was mentioned by Phil previously, it's a very linear retail park with strong active travel connections. So if you go to the southern part of that retail park, you can walk quite comfortably between the shops there and the existing Tesco store. So I know this area really well. I'll park my car and I can walk to and from multiple stores in one trip without the need to go and change my car parking position at all. And it's because the inherent design has been, the focus is that you can do that quite comfortably and it's not a problem. You expand the retail centre across the other side of the carriageway. I personally would not feel comfortable or safe doing that link trip across the main road with a shopping trolley. Until it's just not as comfortable as it should be, and because of the distance between the store of the Tesco and where these units are proposed to be built out, they've put them as far away as possible, making that link trip even harder for an individual to undertake. I'm going to bring in my colleague Mark Clough, because he's more versed in terms of what the latest thinking is in terms of NPS4 and the design matters and what we should be designing to, because my reading of NPF4 is that we should be retrofitting retail parks, not duplicating what's come already. I think it's quite evident from the experience of Inshes Centre that it's a car-dominated environment in terms of the way it's been designed. Swathes of car parking and then retail units on one edge. I think what I'm looking to do is try and improve the active travel connection between the two where we can. And I appreciate there is a degree of flood risk towards the lower end of the site, but I'm not saying that all of that is subject to flood risk. There's an area that's subject to flood risk. And also look at the potential of having a frontage that encourages people who are parked on the Tesco car park to cross that road. How would you do that? It's a real challenge, and that's one of the reasons why we don't foresee this to be a suitable site to expand the commercial centre to. So I think I'll bring in Mark if that's okay.
Yes, please, Mr. Clough.
Thank you, Peter. Good morning, everybody. Like yourself, I was new to this site as this application came forward, so I didn't. I had to look back at a lot of the history associated with the original application and the appeal and subsequent applications that have come forward. So, when I first saw the master plan layout, I thought it seemed out of step with where policy, both in planning and transport, seems to be going. And that seems to be coming in fruition as more and more policy documents come out more recently. So our initial interpretation of this, that this was a car-borne development, and the comments from Mr. Pritchett earlier sort of suggest that that is the intention, is to make it as easy as possible to arrive by car and then get from that car park to the retail facilities that are proposed. Just looking at the National Transport Strategy that came out in 2020, that's really elevated people to the top of the hierarchy of travelling on networks, with the private car being put to the bottom. You've got the Strategic Transport Review that came out earlier this month that basically makes the statement that the era where catering for unconstrained growth in private car use is well and truly over. That's a phrase that comes out of that document. And also, of course, Peter's already referenced the draft NPM4 document, and there's a policy intent in that to encourage, promote and facilitate developments that prioritise walking, wheeling, cycling and public transport for everyday travel and reduce the need to travel unsustainably. So that idea of promoting a development that is a car-borne development seems to be moved away from in current policy documentation. Peter's absolutely right in his comments that the further you make the distance to walk or cycle, puts off more people wanting to make that connection. And so moving those buildings further to the west of the site obviously reduces that distance and gives the opportunity or the incentive, more like, to have more people connecting with the existing retail park. Now, this is either is or isn't an extension to the retail park. If it is, then the aspiration should be that there is an ability to connect effectively right the way through that retail park by walking or cycling. And at the minute, that layout that was submitted with master plans that came that's been around for a long time seems to be beyond that approach, or not adhering to that approach.
Are you able to comment, or Mr. Whelan, on that, on the implications for the safeguarding for the Inshes improvement?
This is probably best where Gary, as the designer for the Inshes project, came involvement, is probably best coming in and passing a comment, but certainly there will be a safeguarding area that will be required as part of that, and how that layout would accommodate with that would need to adhere with the proposals that were approved by the City of Inverness committee for that route, but Gary may have more information on that.
Mr. Smith, do you want to come in at this stage? Thank you, Mr. Clough.
Yeah, thank you. Morning, everyone. In terms of the safeguarding, we've at every stage we've shared information with the developer on the proposed plans, so that includes AutoCAD layouts of the proposals and the alignment of the proposals, which ensure that the integration of the two bits of infrastructure, so that we're safeguarding that route. So I think the latest information we sent them through was August 2022. That's gone on. My first involvement was back in, I think, 2018-ish.
Okay, I think I'm comfortable enough that we've covered the principle of that. We'll be looking at the details of the layout and the different options. Mr. Pritchett, do you want to come back on anything the council has said there in terms of their aspirations for a more current layout that that prioritises pedestrians and active travel?
I think from our point of view is we don't agree that the positioning of the car park leads to less active travel choices. I think going back to the principle of how the access is formed, we've shown how the access by a T-junction is by far the most appropriate access scenario for active travel, allows much easier access by non-car-borne visitors. It's actually the council that are putting forward all of the road proposals around here with roundabouts. Now, the council has decided that it wants a roundabout here. It wants to maintain the roundabout at the Inshes junction. I think we just don't see that having a condition placing the buildings close to the western boundary of the site, as the condition states, serves any particular function as per the development brief to reduce active travel and promote car-borne travel. We've got neighbourhood shops, we've got a local public house restaurant, we have allotments, we have put forward in all of the transport studies how active travel can be promoted and enhanced with bus routes, with pedestrian routes, and particularly with the site access, which I don't think the council has really ever got to grips with, is we're putting in an active travel junction, which is a T-junction, rather than a roundabout. So I don't think there's much more that we can say on that, but we just think it's too prescriptive and won't serve the purpose that the council thinks it would do. It's unnecessarily prescriptive and would be to the detriment of actually attracting occupiers, including neighbourhood occupiers, I should say. Neighbourhood units, they still do want to have disabled car parking, parent and child car parking, and a reasonable level of car parking at their front door. That's how they operate. So I think we're clear in our position on that report.
Okay, I think I'm clear on both parties. I'll come back to you in a moment, Mr. Whelan. Just want to ask Mr. Gordon, do you want to comment on that in terms of the layout of the site, to know that you're concerned about sort of transport implications of the development? Can you hit your mute button? Yeah, if you go ahead now.
What I was saying was just before we went to the break and when I gave my evidence last, and now there obviously is still an overlap in the policies. So the conditions should remain.
You support the conditions that the council has suggested?
Yes, and as well as your previous reporter.
Okay, that's helpful, thank you. Mr. Whelan, you wanted to come back in on this matter before we move on?
Yes, it was really just to help you in terms of your consideration of this condition, and just to look at the Highland Council's document number 36, which shows the Inshes Junction improvement works. It shows not just road improvements, there's several active travel connections as well that's being proposed on that plan. The drawing itself is appended at the back of the report of
that one.
That's one, yep. I appreciate your copy might be in black and white, but mine's in colour, and the colour version is better to look at in terms of looking at all the footpath connections, etc. So is your the land take requirement as well in terms of building out that scheme. And whilst the Highland Council hasn't lodged a planning application for that, that will be imminent, and therefore the precise detailed design of that will be available very shortly. Gary tells me that it's coming early in the new year, and by moving the buildings closer to where those active travel connections are being put in place, really facilitates a linked trip. And by pulling the buildings right towards the back of the site, it discourages people altogether, is my point. And I think if you look at that layout in terms of the land requirements, just to satisfy yourself in terms of the land taken and what would be possible. And we aren't saying every single building needs to front. We're saying has a principal frontage to the road and to facilitate and attract people to undertake that link trip. Gary, sorry, you want to come in?
Just for clarification, the planning application will be lodged this year. I'll go in tomorrow, I think.
Can I just clarify, Mr. Smith, is that based on this layout? So there's no there's no changes in terms of that layout?
That layout was approved by committee back in November 2021, and we've been developing that. There is no material change to it. It's the same.
Just whether or not I need to ask for that and give parties the opportunity to comment on it. But I think if it's based on that layout, then I'm comfortable that I've got the most up-to-date layout in front of me. Thank you. Okay, I think I understand where everybody's coming from in terms of condition 7. Will we move on? Next one I wanted to have a look at was condition 8. Again, the version that's in the council's hearing statement. And this relates to that the details shall show the site layout, building design and landscaping, minimising impact on key views from the A9. And the reason given is to ensure that design of the proposed development achieves the high quality to which reference is made in paragraph 2.23 of the Inshes and Regmore development brief. Mr. Pritchett, do you have any of your comments on that revised wording from the council?
I think it's reasonable. I think that the way in which the site levels work, that will be the case. And I think how we have orientated the allotments, which would be towards the rear of the site. I certainly hope that that's what we can do. I think that it's going to be all down to the details. I was just thinking there, key views from the A9. I think we did do this, Peter, probably in the earlier proposals about where those key views are, but I think it's as you're coming down the hill. But I don't think there'll be a huge discussion about where those views are and what you can see. So
I think there are some images in the development brief of where it's most visible from the A9, if I recall.
Yeah. So I don't think we have a lot further to say on that.
Well, that's helpful. We've got agreement. Anything further you want to say, Mr. Whelan?
No, I don't think so. I think the evidence is the site is visible from the A9 as you're heading northbound, and but positioning buildings towards closer to the A9 as well. They will be more prominent from the A9 as well. So that's all.
The last condition that I wanted to have a look at was 17. And this relates to public transport and active travel. So again, from the council's hearing statement, details shall demonstrate appropriate public transport and active travel provision, car parking, informed through an up-to-date parking study and review of national policy, electric vehicle charging, cycle parking facilities, and development servicing arrangements. And then a caveat that no trading from any part of the development shall commence until the approved infrastructure has been implemented. And the reason being to reduce car-borne customers and in accordance with national policy. Again, Mr. Pritchett, I think you'd made some initial comments on the suggested wording, and the council have changed that. Do you want to come in on?
Yeah, I just think again, this will mean going back into issues of first principle, and I think that should you grant planning permission in principle, I just don't think it would be appropriate for us to then have to go back and look at a car parking study and if you like, reanalyzing the principle of car parking, where it is, what it is, and active travel. The point where we're at in the process, I think, is we've dealt with all of these issues. We fully appreciate that policies change and matters are brought up to date, and we know that you're looking at all that, but there are enough conditions within the original reporter's decision and in conditions in this consent which deal with these issues. I think that we're talking about the physical works that we would do, and we're happy to do those works. I just don't think it would be appropriate for us to have to go back and re-justify parts of the development if we have planning permission in principle. We just don't think that would be appropriate at that stage in the process.
I mean, my reading of that is more the details of these provisions. So, I mean, you're not seeking at the minute the approval of the number of car parking spaces or necessarily the layout, although there's a thing about whether it's the indicative, and details certainly in terms of the amount of electric vehicle charging, cycle parking and servicing. I'm certainly not clear that I would, at this stage, all of those details are in front of as part of this application. So I'm a bit unclear why this would be going back to sort of reopening. Maybe perhaps you can better explain that for me.
My worry is about having to re-justify the principle of development. I do accept that if we have planning permission in principle, we have it with all matters specified for conditions. I just thought that to do with levels of car parking, we would be abiding by the standards of the council at that time, rather than having to then re-justify what we're doing. So I don't think we have a huge difficulty as long as the other conditions specify what it is that we need to do. But I think our view is that we don't want to see a condition that reopens up a debate about whether we should or shouldn't be doing certain things on the site, or in terms of bus provision, bus priority measures, pedestrian and cycleways, which we think we have already done, and clearly will tie in. If Gary is lodging a planning application for the roadworks, we're going to have to tie into that if that's what we need to do, and we would do. So any matters specified would tie into those works. So I don't think we have potentially major issues, but I just don't think we want to get to a position where we're having to re-justify issues of principle at the stage of clearing conditions.
Okay, that's helpful to understand your concerns. Mr. Latta, I'll come to you in a wee minute, but perhaps Mr. Whelan can help us by explaining the council's intention for that policy.
It's simply the matters of detail. It isn't going back to the principle of the development. It's about how that development would be served, and the detail of the matters set out in that condition we would expect to attach to any planning permission in principle. We don't have an approved layout for this scheme. Far from it, it's still speculative development. They don't have end retailer units lined up, so each retailer may wish to have slight nuances in terms of how they will be serviced, how they will be accessed, what their requirements are. I think it leaves the opportunity for those matters to be agreed at the matter specified in condition stage. That's my position.
Okay, that's helpful. Certainly, I didn't read it as having any bearing on the principle of development. Mr. Lato, do you want to come in on that?
Thank you, Reporter. Yes, I don't think there's an in-principle concern difference here. I think the issue is and it can all be dealt with through condition and AMC matters once greater certainty of development is identified. I think the thing that concerns me and the appellant as well is additional parking surveys. You know, the council, like all local authorities, have their parking standards for development. Various councils are currently looking at that in light of MPF4, SPTR, etc. And it, you know, clearly the development here, you know, would be delivered in compliance with the council's design standards. So I think the addition of additional study, which I'm struggling to see what additional information that would bring, it comes down to, is it required? And I would suggest not, and a more standard condition would be more appropriate.
Yeah, Mr. Whelan, it'd be helpful if you could elaborate in terms of what the council's expectations would be in relation to your current parking standards.
I think it's an interesting point. This particular part of the city centre, or not the city centre, I should say, of the city, has a level of car parking provision which doesn't just serve the commercial retail park, it also serves adjoining employers as well, for example, the hospital. So I'm aware of acute parking issues at the hospital and staff choosing to park their cars at the retail park and walking to and from the hospital, for example. But in cases, they've also introduced time-limited parking arrangements for the Aldi store that's recently been extended, that have gone in, I believe, over the last couple of weeks. By getting an understanding, and the council having a better understanding of how the existing car parks are used and how they're functioned, it gives us an idea of any capacity constraints in terms of parking in that area, and gives us a chance to look at that and have an informed position to assess any future parking provision at this site. And I'll let Mark come in if there's anything extra he wants to add.
Mr. Clough, do you want to add to that? No, then I'll let the appellant come back.
Just to confirm that the council does have its own published parking standards. They're in the document, our roads and transport guidelines for new developments. For retail parks, it's defined as being assessed on merit, which is part of the reason why Peter sought a condition associated with parking studies, just because we need that justification for the levels of parking that they're looking to actually propose for this development. And also as well, it's just looking at the layout. Mr. Pritchett made the point earlier about having effective walking connections from parking areas to the facility. Now, the layout at the minute doesn't provide any facilities for people driving into this site and then walking to the retail units. They have to walk with the traffic through the parking area. So it's just making those points that the parking study should be looking at those types of issues to actually demonstrate the effectiveness of what they're actually be proposing.
Okay, thank you. Mr. Pritchett, Mr. Latto, Mr. Latto, does that help explain why the council would be looking for something more bespoke rather than just a standard?
Not
which
really.
there isn't
every retail park and every development has to be judged on its own merits within guidance, whatever that guidance says. And I think, you know, a more standard condition on parking to be agreed through AMC would be reasonable and give the council the safeguard it needs. I don't think a generic study of somehow is going to answer the questions that Mr. Clough and Whelan have just suggested. I think that would be considered under the merits of what the development is at that time.
If the council standard doesn't have a fixed amount or a range of car parking and is just assessed on its merits, on what basis would the appellant determine how much or how little car parking is needed?
I think there was a slight contradiction in the officer's responses, is that I don't mind doing parking studies for the development. I think what I think we would object to is if, as officers were saying there, if there's a wider parking issue with, if it's Regmore Hospital or it's Beechwood Business Park, where I know they have restricted car parking, and I was interested with Peter saying that Aldi are now putting in parking restrictions. if there's wider issues with parking in the Beechwood, Regmore, Inshes area, again, I think it just needs to be clarified what this, if there's to be a parking study done, it should be related to this development and the requirements of this development. I hadn't realised that, well, I know of parking issues around all of these areas, but again, I don't think it's for us as an applicant or appellant to deal with issues that might be of a wider significance and a wider issue. Maybe it requires some rewording as to, it's very non-specific. An up-to-date parking study, it could mean anything, and to go by the conditions circular, I just quite like to know what that means. And I think this discussion just now suggests that it could mean all sorts of things which would cause us a difficulty. So if you're going to have the wording of an up-to-date parking study, I think it needs to be specific as to what it is. Is it for us? Because I was not aware there's the wider parking issue that we need to address in this area. So, and it would be pretty difficult for the appellant to go away and do a wider parking study encompassing, Beechwood, for instance, and Regmore Hospital. So that's the difficulty I think we have with that condition.
Well, certainly, I mean, anything that's within the condition does need to be necessary and related to the proposal. So I take the point, and certainly the discussion has opened up things that I wasn't aware of either in terms of parking issues in this area. We perhaps don't need to resolve it fully today because there is the opportunity through the written submissions. But Mr. Whelan, is that something that the council could look at in terms of tightening up that suggested wording, just to make it clear what is required in relation to this development?
I'm sure we can confirm that through writing, and I would just say that in terms of parking provision for the commercial centre as a whole, I think that's the point, because you're introducing additional shops within an area where you should have shared parking arrangements that services all those shops. So a parking study of the site itself in isolation wouldn't tell you anything, because none of the shops would be open at that point. We need to look at what the provision is on the doorstep, and that is the commercial centre, and to see what parking pressures there are across that commercial centre to establish what the baseline position is before the development is open.
On the basis that the proposal is an extension of the existing centre, so it's not a standalone retail development. Okay, I understand where you're coming from. Do you want to comment any further at this stage, Mr. Pritchard?
I think it would be useful, I think, if that's the way in which the council wants to look at it. I think the devil will be in the detail of something like that. I do appreciate that the car parking in the commercial centre as a whole is something to be looked at, if that's the case. It was interesting in that the council did refuse us planning permission for the Costa development because of lack of car parking, and that was not that long ago. What for me is a difficulty is that if there are pressures on the commercial centre from outside of that, we may be just finding things out that it's not for us, as it were, to deal with. And it may be something that says, actually, there needs to be more car parking around here because there are wider pressures in the area. But again, is that for us to be assessing? It just worries me slightly, and maybe this will come through with Peter's further iteration of this. I think it needs to be quite tightly defined as to what we're actually looking at here and what we're trying to prove and decide upon. It worries me that this could be a very wide-ranging exercise to satisfy a small part of one condition, of a lot of conditions on a PPP. That was all.
Okay, well, I think possibly the way forward is if the council could suggest a wording in their written submissions, then the appellant will have the opportunity to have the last word on that anyway. So you would be able to include your views on that when you come back with your closing submission, and then that would give me certainly the views of both parties on on that, rather than trying to work out a wording here and not, you know, I think something that you obviously need to collaborate on and have a think through. Would that work for everybody?
Yes, yeah, that's good.
Mr. Gordon, do you have any views on the public transport provision or the links, footpath links between the proposal site and the existing shopping centre that you want to add? Sorry, I didn't, you were still on mute.
Yes, I wish to bring in some more points. It's regarding what Gary said to start with. Will you be engaging with the community before an application is submitted for the phase 2?
It's okay
Yes,
for me to
Smith, you can
answer?
answer that if you want.
Yeah.
I don't need that information as part of the matters that we're looking at in the hearing, but if you're able to give Mr. Gordon some factual information, I'm happy for you to share that.
We had a full public consultation before the committee report back in 2021, which approved the current layout. So there'll be no further public consultation prior to the planning application. We'll obviously take public comments to the planning application of the consultation that we did last year.
What I'm referring to is, as you know, we were involved in the consultation before. Would there not be any further reason for us not to be involved further?
Mr. Gordon, I'm not sure that we can sort of explore this here, but if there is a planning application submitted, yourself and anybody else would have the opportunity to comment on that and put your representations into the planning application in the same way that you've done to this application. So that would be a way of the council taking on board views of interested parties and local residents. Is that fair, Mr. Whelan?
Yeah, so we just like to point out that any planning application that's made, it needs to go through the notification procedures. It needs to go through public advert if it's required. And there'll be an opportunity for members of the public to make representations to the council. And on the back of those representations received, if the council is applicant as well, we will look at those very carefully before reporting the application to committee. And there'll be a further opportunity then for amendments to be made should the designers think that to be appropriate on the back of the consultation and the feedback received from local residents through representations on the planning application itself.
Thank you. Hopefully that's helpful, Mr. Gordon.
Well, what I would like to ask, sorry, further is, as you will be aware, as I stated, we were involved as statutory consultees between the Trunk Road and the Inshes phase 2. But prior to COVID, that was. In other words, what we're considering here today is similar, like to the public inquiry before, and the issues and the problems and the constraints to be placed on that have to be really enforced more powerfully than they actually are. Because the material evidence is quite clear, there will be a net migration problem to the network. We've established this morning already that there is consequences to it being a district centre. In other words, the whole park is in the wrong location. The scale of the development that is proposed will have a significant impact greater on everybody there. In other words, it acts as a buffer site, a protection from the A9 and to the rest of the retail park that's currently there.
Okay, Thank you for that. I mean, part of my consideration of all the matters raised and that we're looking at today is to consider all those impacts. And if we're finishing on conditions, we will be moving on to some of the more detailed matters in relation to the transport network, which overlap with some of your concerns.
Okay, I just wish to bring. I was just
Yeah,
wishing
no,
to
thank you
bring
for
that
that.
in at this
That's
stage.
what you're here for, and your contribution is valuable. Thank you.
Okay.
Can we finish matter one at this point? Is everybody happy that they've said everything that they wanted to say in relation to the matters in points under matter one? Some of them again may come up again because of the overlap with the access issues, but if everybody's happy, we'll move on. Okay. Let me just get myself sorted. Okay, so the second matter really relates to the Inshes Junction Improvements Project, which I understand many of you have been discussing for many years. Hopefully, if I'm not understanding something in terms of the proposals and the overlap, I apologise, and please use this opportunity to ensure that I understand the nuances between the appeal proposal and the improvement project. I've tried to get up to speed as much as I can, but I would welcome any corrections if I haven't got things quite right. So policy 7 in the Highland-wide local development plan, Inshes and Ragmore, refers to the reconfiguration and potential expansion of Inshes Retail Park, provided that expansion helps deliver improvements in strategic road capacity. So my understanding, and as we've already referred to, is that the Council's document 36, which is the committee report of the 18th of November 2021, shows the most up-to-date alignment. And that alignment is different to what was considered the last time, that when the original planning permission in principle was granted. So we now have a new signalised junction off Clawdon Road and a roundabout providing access to both the appeal site and the existing retail park. Am I correct in that so far? What I'm trying to understand, and I suppose trying to ensure that if planning permission in principle is granted for this proposal, that it doesn't prejudice the delivery of the Inshes junction improvement. I think that would be a failing on everybody's part if we didn't get that right. And so I suppose a lot of things relates to the timings of when things happen. And I understand from my reading of the a previous appeal decision notice that a way forward was found at the previous inquiry that allowed permission to be granted, with various caveats if different things happened in different sequences and who did what. So what I set out in my first written procedure notice was that I envisaged that there was 3 different scenarios. The first one being that the junction improvements are delivered, that the council bring those forward, deliver them, and then this proposal is developed afterwards. So in relation to that one, what Mr. Smith has said is that the planning application for those works are imminent. And I think the council in their hearing statement indicated that the scheme is programmed to commence in 2024. Does the appellant have any comments on those timescales in terms of its intentions? I mean, if that was the way it did work out, would that allow for option one to happen, that that the improvement works get delivered by the council and then the appellant brings forward the development on the site?
I think that's always kind of been our hope, that that's what would happen. The delays aren't necessarily anybody's fault, but they're just a matter of fact. If they start to be delivered in that timescale, then I think everybody's happy. I think what our concern has always been is that it's the what if scenario if they don't. That's always been our case, that if they deliver that, then we tie into it. And that option is, as you say, probably the best option for everybody.
Is there still a concern? Is it still necessary to have the other options there? Is there sufficient certainty now that that is going to happen, or are we still needing to sort of write in the plan B and plan C, I suppose? Is the...
Unfortunately, I've been dealing with this site for far too long to think there is a certainty in anything around here. So I've always looked at this is that all we are seeking is a grant of planning permission that can be delivered. And the prematurity argument at the last inquiry was not pursued by the council. And so therefore, there should be no prematurity argument. As a landowner and an applicant, our view is that we should have the ability to be granted planning permission and to be able to develop land within the terms of that planning consent. I think we need, as was agreed by the council at the inquiry in 2016, the either or scenario. Either that is built, or we go back to reasonable planning principles of we mitigate the impact of our development through a no net detriment solution. I think for safety's sake for everybody is we need that other option just in case.
And that other option would also need to ensure that the proposal didn't prejudice the delivery of the improvement project. So it's a line. It's that kind of chicken and egg.
Yeah,
and,
you asked, and we've not necessarily in this process, but we've always provided the council and Gary with plans which showed how any access into this site would not prejudice. They would be in the same location. It wouldn't do everything that Gary is looking to do, but we will be working with Gary to deliver when the council is in a position to deliver. But what we would then be doing is if the timescales get pushed out, as they have been doing, is we would deliver our site access with a no net detriment solution or a contribution or however that works out, but we would be building. And I think that's the correct approach still, is that we shouldn't be being prejudiced by the council doing roadworks that it wants to do. And that's always been our position.
Okay, well, I think that's what I want to try and explore in detail today, to make sure that I have a full understanding of the kind of the implications of particular wording of conditions that allow for those eventualities. I think it's helpful to know where the council proposal is at, and certainly Mr. Smith's going to come in as to, we perhaps are in a more certain position than the previous reporter was. But perhaps, Mr. Smith, can you confirm timescales? Is it in agreed budgets as well as you've obviously got certainty regarding when the planning permission has been submitted. Is there certainty regarding delivery dates?
The delivery dates are the dates that we've suggested in our submission. In terms of capital programme, they are always under review by the council. I will do my very best to deliver projects within time and budget. In
And
terms
you
of the capital
said
programme.
they would commence in 2024. Have you any indication as to how long the works would take in terms of
minimum 18 months.
Right?
I just wanted to raise a point that Phil said that he had provided plans. I'm not aware of any plans that have ever come forward which integrate the Dell of Inshes development with Inshes Phase 2, not from the developer's perspective, other than the plan that was tabled in the report in 2017. But if Phil wants to point me to those plans that are in the documents, then I'm happy to look at them.
So what we put in was this came through your questions, I think, report in terms of the flood issue and the access issue and what we were proposing, and we superimposed the site access T-junction onto your proposals, Gary, of what we had at the time, which is presumably still the same, which is our T-junction sits over your roundabout onto the
I don't know whether you can see. I think that's that one.
So that's what we prepared in this inquiry. We haven't produced, Gary, any other new documentation since the inquiry in 2016. But what we were asked to do then, and I think what we're still asked to do now, and through the original condition 6, is we would be agreeing not to build on any of that land, and our access sits over the access road that is in Gary's Inshes Phase 2. I think the difference at the moment is, and what we're still worried about, is the reason. One of the reasons for refusal of this application was flooding, and then we have had to spend a great deal of time and effort doing an up-to-date flood study because of climate change, etc. And we, as an applicant on this site, have only been able to put forward the T-junction because of the minimal culverting that SEPA would agree to, and also, to be fair, the flood officer at the council. And the flood officer at the council has said they would only support a T-junction there with minimal culverting because of the flood issue. Now, I agree that Gary and his team dealing with strategic road proposals will be dealing with that, but we as an applicant can't. We're just having to access our site and deal with the objections raised at the time. So that's why we have only been able to come up with our T-junction proposal, because that as an applicant is all we can actually deliver at the moment.
I'll come back to both of you, mate. I suppose what I understand that the council, or what the appellant has done, is not necessarily show the alignment of the junction improvement as part of their proposal, but they've demonstrated that there would be no built development on that part of the land, so that if they develop the site in advance, then the project could come along and, I suppose, supersede, put an alternative access in that could still happen. So it doesn't necessarily implement the improvements project, but it doesn't prejudice it. Is that?
Well, we're going a bit. I think we're going a bit further, because we're forming an access. We're taking trees down. We are putting a culvert in. So all of these things, with in discussion with Gary's team, is we're doing part of all of those works.
But if I'm looking at the most up-to-date alignment of the junction improvements, neither of the options in terms of illustrative layout, the one with the roundabout or the one with the T-junction, align fully with the council's project as such. So I suppose that's where I'd kind of my options 2 and 3. Scenario 2 was that part of the junction improvements could be delivered through the proposal. I would envisage that you would take that proposal that was approved by the council in November 2021 and form that as part of your development. And then the third scenario was that sort of no net detriment, that you would come up with something else that wouldn't prejudice it, but it wouldn't necessarily implement it.
I think our problem has been as a landowner, an applicant looking for planning permission, is we've been refused planning permission based on flooding grounds, and so we had to deal with that issue. And the only way we could deal with that issue is getting SEPA approval to withdraw their objection, and we could only do that through the Kaya Consulting flood report, which suggested that the culvert would be acceptable within the confines of a T-junction. So we're having to tread that fine line in the middle.
Can we maybe stop there, because I'd quite like to get the views of the council on that, the flooding and the alignment issue, because it was certainly something that I'd picked up, and as I'd asked in my previous procedure notice. Obviously there was an objection from SEPA at that point, but yeah, just to understand that, because there obviously is part of a flood zone in the part of the land where the access road comes forward. Are the council comfortable that the roundabout solution is the way forward and has been agreed with SEPA, or would that be done through the planning application? Mr. Smith, do you want to come in on that?
Yes, please. In terms of flooding, I can appreciate the developers' issues with developing the whole footprint of the site is quite large in terms of the overall area. The footprint of the road, the access road from Culloden Road down through the site is not nearly the same extent, and that's so our two flooding issues are relatively unrelated. Developing a whole site is different in terms of flood terms than the footprint of the access road. To allow.
I think it's only the area near the burn that is within a flood risk area. So certainly my understanding, I know there's surface water issues for the rest of the site, but in terms of SEPA's flood maps, it's the area that the access road from Culloden Road comes into the site, and the access, that's where the flooding issues are. So I kind of was taking it that the issues were similar for both projects.
I mean, I guess there's discharge issues from the site as well in terms of that, but we have been in discussions with SEPA on this, and it will be resolved through our planning permission.
Okay, that's, I say, I have a response from SEPA now, and it's out with my scope to resolve any flooding issues in relation to the junction improvements. I'm just making sure that I'm looking at the matter from the point of the appeal before me. So in terms of is the council still concerned that the development would prejudice the improvements projects, or are you comfortable that with the wording of conditions to cover the three different scenarios that the development could go forward and it wouldn't prejudice? Mr. Whelan, you want to come help us with that?
Yes, I think I would just draw back to the past reporter's decision, and there's a key paragraph within that. What I make clear in the second or third sentence, I should say, in paragraph 50, is that any permission that is granted should be the subject of a condition requiring access to be taken from a signal controlled junction on Culloden Road. So the applicant's suggestion of a T-junction arrangement onto the existing road network without that connection to Culloden Road would not be acceptable to the council, regardless of the timescale of when the Inshes Phase 2 project takes place or not.
And the reason for that view?
It would not demonstrate no net detriment to Inshes roundabout. It would be helpful if Mr. Pritchett comes in just to confirm that's his understanding as well.
Mr. Pritchett, because I know there's various no net detriment proposals have been
Right.
put
So
forward.
the nub of this issue is, and it's always been the case, and Peter wasn't there, but the council solicitor was there in 2016, and this is where the either or scenario came in, and we think is still crucial, because again, I would repeat that we're just an applicant seeking a deliverable planning permission and to mitigate our development. The premise of that position from the reporter, and also in the brief, that access must be taken from the Culloden Road, assumes that the council will shut off Tesco's access onto the Inshes roundabout and, as it were, implement the Inshes phase 2 works, and that's fine. And we have no problems with that and would like it to happen. Our problem is, and our concern is, if that doesn't happen, and who knows whether it will or whether it won't, it is the council's proposal to put those roadworks in, and our problem is what if that doesn't happen? And the reporter's decision was that you then default back to a no net detriment scenario and our own site access, because you can't put in, well, Gary can correct me if I'm wrong, is you can't put in an access from Culloden Road unless you are shutting off the Tesco access from the Inshes roundabout. And we're happy with that, and Tesco we've all had these discussions, but our concern is if that all doesn't happen, what do we do with our site? And we've always taken the view that we would then access our site from a T-junction, and we would pay for, or well, presumably pay for, works on the existing road network was a no net detriment solution, whilst still, as condition 6 of the reporter's decision said, safeguard land if and when the council want to do their works. And that's what we've always taken the view on, is that's what we would be doing. And we've tried that, we've failed, but that's what we've always based this decision on. But yeah, I think we'd all be very, very happy if Gary's proposals ran forward and they built out their roads which we could access from.
That's very helpful. I mean, it took me a long time of reading through all the stuff to understand all those, but I'm reassured that my understanding is what you've put forward, Mr. Pritchett. Mr. Latto, do you want to comment, and then I'll go to the council. I think you're still on mute.
Yeah, thank you. I'm just making sure we're up to getting 2 volumes on the same time. We've, again, as has been said, we're hopeful, as the council is, that they can deliver their phase 2 works in good time. To put into context, and again, without any blame or anything, at the 2016 appeal, the council's position was they deliver phase 2 by 2020, and that was our official position, and that's in the reporter's report. Understand there's delays for all sorts of reasons. We do still think, the proposed timescales are optimistic, and I think I hear what Gary's saying, that he will do what he can to deliver it within the timescales suggested. But there are matters out with the council's control that need to be dealt with, and it's not just with the appellant. There are other parties involved and other processes involved. So it is a highly complex process. The council has a long way to go, and while we hope they will deliver when they say they will, there are no guarantees.
Can I just ask, as a quick follow-up to that, my suggested sort of scenario 2 was that, I suppose, that the appellant helps out the council and basically if the council gets planning permission for a scheme, could the appellant take its part of it and implement it as part of the development of the appeal site? I mean, that was one option that I'd asked for views on. So it's almost like, rather than a contribution in kind, that you achieve your access and you're contributing to helping the wider junction improvements.
I think that's why the either or before was accepted by all parties, and that, you know, if that's through, you know, contribution, and again in accordance with the circular, absolutely, you know, that shouldn't be an issue.
That would be, I suppose, what I'm looking at is an either or, because the third one, I suppose, is what the appellant has tried before, which was to come up with a what it considered to be an alternative no net detriment proposal that I understand wasn't acceptable to the council.
Well, I think what was
it's just trying to make sure. I'm trying to understand.
Before.
Do I need to consider all three options as potential, or is that one? I understand that the first one, that the proposal happens, is certainly on the table, allowing for the appellant to bring forward an alternative if the junction improvements doesn't take place, needs to be covered. But I suppose, do we need to cover that option in the middle? Is that something that the appellant would be potentially looking to do to, I suppose, facilitate the development of their site? Sorry, Mr. Pritchett, you're still on mute.
There are many moving parts to that second option, of which neither the council or the appellant are actually necessarily in control of, and I think it comes back to reasonableness. I think having the either or is probably a more sensible and coherent option. The council don't have planning permission. While they've got council approval for a scheme, you know, last November, that may not be the scheme they build for all sorts of reasons going through the planning and approvals process. They have changed the design over the years. They may well have to change the design for a number of other reasons. So, you know, holding the appellant to further what ifs by others is I would think is challenging, and it would be very difficult to deliver.
That's helpful. The council, Mr. Smith or Mr. Whelan, I mean, is that was an option? I think the council said, yeah, that might happen, but it's unlikely. It's just, do you think we need to factor that into the potential scenarios, or, as Mr. Laddo says, is it just too complicated and actually we're better dropping it?
I would factor in all three scenarios, if I was honest. I would also draw your attention to condition 5 in the second part of condition 5. I was listening carefully to what Mr. Pritchett had said. If they were to introduce an interim measure themselves, for example, T-junction arrangement, make a cash contribution towards the wider Inshes phase 2 works, effectively relieving them of their mitigation, passing the burden on to the council to deliver the works on their behalf. That wouldn't comply with condition 5, second part, because condition 5, the second part, requires that the applicant introduces the no net detriment scenario and that it's constructed and brought into use. So a cash contribution doesn't mean it's constructed and brought into use before the store opens. I don't know if you're following that, but
yeah, I'm just trying to get, because condition 5 is from your original appeals.
sorry, no. Sorry, condition 5 of the last appeal decision is what I mean.
All right, just a wee minute, I'll just get that up.
So in terms of the either or scenario that was agreed last time round at appeal.
Right, and did you include that wording in your suggested?
I'll have to check. Bear with me. I don't think I did deviate from it, but Mr. Pritchett can correct me if I'm wrong.
Yeah, right. I've now got your response, your appeal statement, which outlines all the conditions other than the ones that you suggested alternative wording for.
So my condition 13B of the
Fantastic.
suggested condition. So the last part's the critical part. So the parking arrangements. So access and parking arrangements have been constructed and brought into use. The crux of the matter is if they introduce a T-junction arrangement and proceed before the council do any works to the road network, they're putting additional burden on the road network at that point.
Yeah.
And I've suggested that a cash contribution in addition to that might be sufficient to relieve themselves of that second part of that condition. And I was drawing your attention back to the original Porter's decision, paragraph 50, made very clear that for any permission, they would need to deliver that connection to Culloden Road. I think the detail that's set out on a drawing is the SK4 drawing, I think it was. That basically wasn't lodged as part of this application, but was referred to in the last appeal decision.
Yes, that's the one that was. But then that drawing was based on the former layout of the junction improvements, so it wouldn't be appropriate to. That's out of date now, as far as I can.
It is an interim drawing, I suppose, in relation to the council's phase 2 works that have moved on since then. That design has moved on, and I'll bring in Gary there just to explain the differences.
Just to say that junction is in exactly the same position as it was in the previous. That junction onto Culloden Road has not changed position since the original. That's one constant. The change is in the form of the Inshes roundabout. We have chosen to reduce our footprint in terms of the roundabout and retain the roundabout rather than building a new signalised junction there. To retain the roundabout and have a signalised roundabout in conjunction with the new signalised access to the Inshes Retail Park. That Inshes Retail Park access has remained in the same position, and in fact the SK4, which was mentioned in the last appeal, shows the existing retail access to Tesco and the Inshes Retail Park coexisting with the new signalised junction, and that was prepared by the appellant.
Looking here at the wording of the council suggested condition 13. In part B of that only just says that access and parking arrangements demonstrate that there'd be no net detriment. So I don't see how that refers back to the junction improvement works. Well, the reason refers to the requirements of the brief. The wording of subsection B would just allow the appellant to explore an alternative access arrangements, is my reading of that. Doesn't tie them to a particular layout. Access arrangements,
It doesn't tie them to a precise layout, no. So they could come forward with a no detriment solution.
Yeah, which is what the appellant's looking for as an option.
They could look at reconfiguring the roundabout design, making different changes that perhaps they haven't trialed before. The point being is that those changes, those amendments that demonstrate no net detriment.
Yeah, which would be is not a matter that we can address through this proposal. That would be something for the appellant to address at a future date with the council. I suppose what I understand what the appellant's trying to do is leaving it open for them to be able to do that if the junction improvements don't proceed on a timescale that works for them. Is that Mr. Pritchett, is that correct?
This is the exact issue we've been facing from frankly before 2013. is we've been working with the council for a long period of time. And in fact, it was the proposal to access this site from Culloden Road was Craig Latto's drawing back 15 years ago. We would have no difficulty in accessing the site from Culloden Road. What that Culloden Road access has become is the Inshes Phase 2 improvement works, which shut off the Tesco access from the Inshes roundabout, which nobody is in control over. So that's why the or scenario is very important for us, because, well, we're here now discussing the renewal of a planning permission, which was granted 5 years ago. And I hate to think that we'll be here in another 5 years discussing exactly the same things, which is why the or scenario, and as Peter said, a no net detriment solution with a site access is what we really do require to keep in the process.
So are both parties satisfied that the wording of the council's suggested condition 13 covers the scenario, the two scenarios that are needed? I mean, A seems to be the scenario that the junction improvements are delivered by the council, and even if there is some lag, they're still relying on the delivery of it. So it's that kind of certainty that the junction improvements are going to come forward as proposed, and B allows the option for a no net detriment to be explored if that's required.
So this is what we lodged in 2019 as because of the delays for nobody's, nobody's at fault, but the delays in bringing forward Inshes Phase 2 meant that we tried to, because we knew the clock was ticking on our consent, we tried to have a T-junction access approved with a no net detriment solution. And that application was refused for one of the reasons, which was it did not have an access directly from Culloden Road. And we didn't appeal that because we just thought, well, our consent is still moving forward and we wanted to see if there was a solution and see if Gary's team could bring forward Inshes Phase 2. Now that's not happened, which is why we need to renew. But we are still.
Can I say, was there anything in the original permission that required an access from Culloden Road?
Well, this is what Peter's saying is the text in the reporter's decision did say that.
Right.
The condition then didn't, and I think quite rightly the condition didn't, because in order to do Gary's proposal, to put Gary's proposal of a Culloden Road access into our site, the council's Inshes Phase 2 works shut off the Tesco access from Inshes roundabout, and that's absolutely fine. If we were to come forward simply with an access from Culloden Road and nothing else, then that would be, as it were, our solution. But that's not really where matters stand. And so the or scenario of a site access with a no net detriment solution is what we would prefer to still have in this consent process. The thing that we have in the discussions to date is our no net detriment solution is pretty much exactly what the council did in 2017, which was to put further slip lanes onto Culloden Road and Sir Walter Scott Drive to facilitate better flow of traffic at the junction. We would simply be adding to that. Now that can be done, but Gary quite rightly doesn't want that work to be done because they're going to be doing a different junction arrangement. But that's the no net detriment solution, which we want to still have there as an option going forward.
Okay, I mean, it's obviously not within the scope of this appeal to discuss the merits or otherwise of a no net detriment solution and whether or not what the details of that are, because I assume that would require to be supported by a lot of technical transport assessment work and looking at that. But is the council happy that that option for the appellant is still left open, and if not, why, you know, where does that leave the this kind of the need to make sure that one development doesn't prejudice the other if permissions are granted? Mr. Whelan.
It's all right. Yeah, just a couple of points, and then I'll bring in Gary if that's okay. I point you to the direction of the last appeal reporter's decision, condition 2A. It explains what the vehicle access arrangement should be, and they should be in line with SK 0041. And that shows direct access onto Culloden Road. And the other point I wanted to raise was my condition.
Sorry, can I just get 2A in front? Okay, so I've got that. So the access arrangements shall accord with the brief, and in particular, as shown generally on the drawing that I don't have in front of me. So I obviously can't have the same condition because I don't have that drawing.
We talked previously about a form of words that you could use to require a signalised junction connection with Culloden Road,
Right.
rather than a drawing. And that could form part of the fallback option, the either or scenario. Just not to lose sight of that.
Could the council respond to Mr. Pritchard saying that the appellant would be unable to do that because of the implications for the traffic going to Tesco's from the roundabout? So could you put a signalised junction off Culloden Road and still have the roundabout operating as well?
Gary?
Yes.
Does that alleviate your concerns, Mr. Pritchard? Maybe Mr. Latto is able to comment.
Again, the council can do certain things that we can't do. We were refused planning permission this time round for flooding issues. We've had to reduce our access to the T-junction because SEPA objected and the council refused us planning permission. I'm sure Gary and his team can do things that we can't do in terms of forming an access off Culloden Road and doing compensatory storage of flood waters, etc., etc. We've been refused planning permission on those issues. Again, my worry is that we're trying to find a way to build this site out, as we have other sites around here, with as simple a solution as possible and making sure we do not prejudice what the council would like to do in the future. We're quite happy with what the council's going to do, and it has, you know, larger and wider road proposals, which we're interested in. But we come back to the point is we don't need these works to mitigate the impacts of our development. We're quite happy to be involved in those works and facilitate those works where we can, but we're trying to get through this planning process, which we're failing to do at the moment, and we're trying to find physical works that everybody technically can be happy with, and that's the position we find ourselves in at the moment.
Yeah. Okay, we'll come on to in terms of sort of the mitigation and the need for the improvement works, because I think that kind of comes under the developer contributions as well, which we'll have to look into. Does anybody have anything additional to say? Because there's a lot there, and I will be appreciate if you can cover these matters in your closing submissions, just so I'm clear where each part is coming from in terms of trying to find a way forward if planning permission is granted. Mr. Smith, you want to come in?
Yes, just very briefly, thank you. It's just on Phil's point about, or sorry, Mr. Pritchard's point on the council can do things that a developer can't. That's not true. we have to apply for planning permission and apply with for SEPA car licenses, etc., in exactly the same way as a developer. So there is nothing that we can do that a developer can't.
So there may be scenarios where the benefits of a strategic road improvement is seen to override some other concerns. I know that the wording of some policies allow for if things are for a greater public benefit. So potentially that's a scenario where it may mean that the goalposts are slightly different for a roads proposal versus a private development. But I appreciate the comments that yes, planning permission and all the relevant approvals are needed from the roads point of view. Does next, Mr. Whelan, I think you want to come in first, and then I'll come to Mr. Latto. Really, just now, if you have anything additional to say, because I think otherwise we'll be going over and over and not necessarily moving things on.
There was a couple of things that Mr. Pritchett had suggested that the council were being difficult in terms of refusing for certain reasons. He said that he tried an all detriment solution with an access that was refused by the council. It was refused by the council because it didn't provide that connection to Culloden Road. It wasn't proposed. Second point was it was refused under flood risk grounds. The studies that were undertaken by the applicant didn't look at a connection to Culloden Road or a roundabout access. So they've come forward with a minimalist intervention in terms of a T-junction to satisfy flood risk grounds, but they haven't assessed the fallback position of making a connection onto Culloden Road. That's not been proposed. So if he wants to include it as an option, that's fine, but we still need to see that detail.
That wouldn't be for today, but it may be as an alternative no net detriment solution if that was needed. So I suppose it's in this case it would just be allowing for that to be explored. It's not for this appeal to find that no net detriment solution if it exists. It's as far as I can see, it's just allowing for that further option to take place if it's needed.
Just the last point really was if that secondary option is needed, that the wording in the appeal decision and the condition that's put forward by myself in terms of the wording of 13B requires it to be constructed. That's key.
Mr. Latto.
Thank you. Yeah, just for clarity, condition 5 of the decision notice is an or scenario. The council again seems to be conflating that with an and scenario where the applicant delivers both the link road and a no net detriment at the Inshes roundabout. It's inherent in the or scenario.
Sorry, can I just,
when a no net detriment solution at Inshes roundabout is delivered.
Sorry, Mr. Latto, this condition 5 in the previous.
Dell of Inshes site has a site access, which is therefore not the link to Culloden Road. Otherwise, that would be an and scenario. So I think for clarity, it's a no net detriment at a very localised part of the network, and it's a site access onto the existing network as either as a roundabout or a T-junction, but the one that clearly has removed SEPA's objection is the signalised T-junction.
Can I just check? You said condition 5. Is that condition 5 in relation to the previous appeal?
That's correct.
And would those comments apply to suggested condition 13 from which the council has suggested for this appeal?
Yeah.
Okay. Yes, I think that it's that wording provides the two scenarios. The preferred solution, I think, from everybody's point of view, is that the Inshes improvement project goes forward at a timescale that suits, and the appellant could then deliver a proposal in line with that. The or is if it isn't, and to allow for that. And I understand that that was the nub of a lot of the discussions at the last appeal. And I think what we've clarified today is that we need both of those on this. And it's just if either party wants to comment further on the suggested wording that the council put forward in terms of condition 13, then you can do that after in your written submission. Does that seem like an appropriate point to leave that? I think it's certainly been very helpful for me to explore a lot of the history and the different scenarios that we need to cover. Let me take stock of where we're at. I see we're at 1:05, so it's probably we'll perhaps just do the last part of matter 2B, which relates to condition 15, because I think it does relate, and then we'll take a pause. We'll take a break for lunch. Would that be okay? And then we'll start again on at matter C. So the council suggested condition 15, which is kind of overlaps what we're discussing, says any details shall show the access arrangements according with the council's design for the Inshes Junction Improvements Phase 2. So that in my mind would almost preclude the a no net detriment solution that proposed an alternative access. Now I understand that the reason given for that condition relates to pedestrian links, but is condition, maybe the council can answer, is condition 15 meant to relate to vehicular access, or is it in relation to pedestrian access? Because in my mind then, if you have, it kind of contradicts part B of condition 13.
Yeah, it does.
Am I right?
It contradicts it, so we're going to have to think about the wording of that to allow for the either or scenario in the first
Right.
sentence of 15, and it does specifically relate to pedestrian links.
So if condition 15 was reworded to allow for the either or scenario, would that work for the council?
The
Did the
important
appellant
part
have a view on that?
are A and B.
The appellant in their original comments on condition 15 thought it should just be replaced by existing condition 2, which that's the one that referred to the drawing, which we don't have, but then also in the second part, 2B in the existing permission said pedestrian link shall be provided between the development and existing retail units, and a pedestrian link shall be provided between the development and the houses to the southwest at Woodgrove Crescent. I think if the council provide an alternative wording, I think what you were trying to do is what 2B required. It's just it has wider connotations that perhaps we very difficult writing conditions. Mr. Pritchett, do you want to comment?
Yeah, it needs clarified, and that's what I think we were pointing that out is that if it's about that, it needs to state that that's what it's about.
Okay, well, if I could ask the council to do that in writing, and then Mr. Pritchard, you'll have a chance to comment on that. Mr. Gordon, would you like to comment on anything relating to what we've covered in terms of the mitigation and the proposals in relation to the implications for the junction improvements?
As I stated earlier on, the whole project and the scale of the project can't be sustained on the infrastructure as it is. So in other words, I can recall a couple of years ago, there was a volume of figures, maybe 9,500. There's probably 25,000 plus using the accesses and the networks. This is what I was referring to earlier on. In other words, the Inshes Phase 2, the part that was done last, and even what comes forward, or even any improvements, as I said earlier on, with the T-junction or the roundabout, will have a severe mitigation to the properties. In other words, the amenity on our lands and our properties will be blighted by the development.
Okay, thank you for that. Okay, we've got through a lot, but we still have quite a bit to get through. Shall we take a break there for lunch, and we'll come back and start matter 2C, which relates to condition 14. And how do people feel about starting again at 1:45? Is that too short? Does anybody need a longer lunch break, or would 35 minutes be sufficient? Okay, take a break there, come back at 1:45. Thank you very much so far.
We have some hot water.
Pardon?
We have some hot water.
Yes, this is Murdo.
How you doing?
Joy Spriggs,
Well,
David, her husband, was school dentist in the area. And they were at the barn for quite a while, and now they're at Smithton Tree Church. And Joy brought me a Christmas package. Have they asked you? Did they ask you to come on while I was here?
Well, I've been on again just now.
Did they get you?
Aye,
Did you get it?
aye.
Well, that's good, Mother. You put it on to,
No, I just left it as it was. So,
but they heard you.
why? But I'm finding it's, she's only asking me just relevant at the stages.
But that's better because you were scheduled technically at the end to speak. But I like the way she's asking you to come in and what do you think?
Yes, what I'm trying to say is,
Because some of the other guys don't say anything.
well, there's 2-3 people there.
That do most of the talking.
Aye,
Answer the,
but they're getting their chance more than me.
I know, but even so, Murdo, even so, you're the only non-technical local person who knows you live there and you experience it. Your property's next door. This hearing is all about the development of this piece of land, which is hidden away. You don't see it. It's a big piece of quite attractive land. This Tesco Inches is there. And if you
You don't have Inches.
Yeah, it's a whole big area.
Yes,
It's a bit next to me now.
yes. Are they trying to develop that then?
Well, they are trying. But since 2003, I'm trying to solve them.
You're trying to stop them?
Yeah. So this is the purpose of today.
Well, let's be honest, David is dinner, and then we've got to go to Nethy Bridge. So-
Yes, that's today.
Yes, we're going out there today.
Oh, well, but
So
thank you so
God
much.
bless you.
Yeah,
You get your
thank
hope for
you.
Christmas.
Thank you very
Bless
much.
you. God bless
Thank you.
remembering you a lot.
Thank you.
And what's his
And
daughter?
remember me to Joy.
David, I will indeed, thank you.
That's all right, they've gone off. And they've gone for a break. I'm not into this. It's my friend that's given us this to do. So, I mean, I've not taken part in this before. I've taken part in an inquiry before when it's been live. So physically, this time it's hands-only. So what was supposed to happen is I was coming in later on in this afternoon, just purely on infrastructure. So of course it's a Dame woman that's leading this. So I'm trying to batter her up to try and cleave all the stupidness between the appellants and between the council. So I'm not in favour of the council because yes, the council turns it down, but the appellants appeal. So my evidence to this is, and more, is to simply say, well, we don't want it, we don't need it, because it'll make the area worse.
So what they wanted to put in? Just
Retail.
another retail?
If
No,
you
they
expand
don't.
it.
They don't need it. No, they don't actually. It'd be good to keep some areas green.
Well,
Yeah,
And you know, and again, to be able to get down there, wherever the road's going, you think that the roundabout by Tesco is the worst one, I think, in the whole of Britain.
It's terrible.
And dangerous. So
He's
it'd be even
speaking on
worse.
that towards the end of the hearing.
Oh, good. Yeah, bring that in because they said it's the worst one in the whole of Britain.
well, you see, the argument that's going to be happening this afternoon with us is between now and then. And my friend picked up on this morning today, is they're not identifying what solution they're going to do, net migration to the roundabout. So this woman is saying in the hearing, we can't talk about net migration.
Oh.
In other words, I just stated there just now, when this all started, there was only about 9,500. There's potentially 25,000 going through it a day.
And there'll be more.
Aye, well, I didn't get to say that part and more, so I'll continue with that when
Yes.
it comes
And do you
with
think
it.
of Torna Green with eventually of 10,000 or the other houses that are going up in Bullock? That would
Yes,
then
but
go
the thing
that
is-
way as well.
You see, the problem lies here is the council talk about these development plans that they make. So what happens is they make them but they don't, what they do with them is they're adopted copies. So they send them down to what I'm dealing with just now at Falkirk. They approve it. It comes back to the councillors to approve it. So an application in anywhere around the town it's not till it's submitted. So just take a scheme like these houses here, for example. Say there was an open field of maybe 3 or 4 acres before these houses were built and phased out.
Yeah, yes.
Take with the colleges, for example. That's a 200 acre site.
Excuse me just a minute, Murdo. When did he say, when did he say they come back?
1:45.
Pardon?
1:45.
Okay.
I was going to say, yeah.
Ah, well, I've got plenty of time. 1:45.
Yeah.
I'm explaining to the process.
Yeah, and obviously there was nothing here. When we came here in 1979. There was nothing.
No.
There was the one street, the bus twice a day.
This is
And it
just,
was it.
this was just a big
There was nothing.
field.
These were all fields. All that was all fields.
So I can't complain
The
about.
expansion has been.
Yeah, but that's what I'm trying to tell you. You see, the problem lies is the Dell down there was like over at the university.
Yes.
That was 200 acres. I've got 10 acres behind me at the back that I'm talking about. And then there was potentially 6 or 7 other sites around the town. So they were all classed as green wedge sites, which means no development could go on them. So I was in favour of the council at that stage until we were getting letters out from developers thinking my mother and I or my neighbours would sell out to them. So the 2 boarded houses that are in front of me sold out because it illicit dirty money, but I can't say that today. So I could if I got ripped into them. I don't want to spoil, as Bart says, it's a wonder that they allow me to take part to say what I'm saying so far, which is not much. You see, I'm not an appellant. I'm not in the final.
I need to get into my, I know this is really what I do.
Yeah.
Well, I'll continue explaining.
Bless you. I wish you all the best with this. Sorry, I shall have to go.
All right.
My husband's dinner because we've got to trot off this afternoon.
No, well,
All the best, Murdo.
thanks. You want me to pour yours up?
Yeah, thank you.
What did you say that lady's name was again?
Joy
Joy.
Sprigg.
Aye. Well, I gather it's
David Spriggs.
Aye, but the point was, I didn't get to finish my point with them about
Did he cut you off?
Well, in between they kind of did. So she wanted us to go for a break for this till we get to the next part. In other words, I didn't get to say that it would make it, well, I said it would get severe, no matter what, by the size and everything.
A fork or a spoon or something?
Whatever will still look best. Probably both.
Was it 1:45, did you say? We
Yes,
would resume?
yeah.
I used to be a nurse
All right.
and her husband was
The dentist.
a school dentist. He used to drive a van around with all the equipment in it.
The bit we're going on to next is developer contributions. So we're getting through it, but again, as I tried to say there, I feel that they're focusing too much on
Just a minute. I've had one for each.
oh, I don't like that.
You
It's
don't
probably
take it?
I've got tomato. Oh, you can even take that one.
No, I got one each.
Ah, but keep them for something else. I'm all right.
You don't want it?
No, I've got a tissue there.
Pardon?
You got a tissue just to sit the fork
Sorry?
on. Have you got a tissue, please?
Yes.
Just to sit this on. Just to sit it on here.
It's just all muted. There we go.
What I did this morning, I pressed it in the middle and it just brought the whole thing.
You doing okay, Mr. Gordon? Put your microphone on so I can hear you. Sorry, I wasn't able to hear you. You don't have your microphone on. From Mr. Pritchett, I think.
Happened now.
It's okay now.
I'm not on it. Look,
Pardon?
there's no sign of me.
Have you switched your camera off, Mr. Gordon? We can hear you, but we can't see you.
Okay.
The camera at the top of the screen, if you click that, you've maybe switched it off by mistake. That's you, you're back.
Okay, we're back now, back.
Yeah.
Yep. Okay, I think that's everyone. Thank you. Hope you all had a good lunch, if a short one. So we have reached matter 2C on the agenda. And this is the final part in relation to the Inshes Junction Improvement Project, apart from the developer contributions aspect potentially of that, which we'll deal with in matter 3. So yes, it's item 4, but it's matter 2, part C. We all got worked out where we are on the agenda. This relates to the council's suggested condition 14, which relates to the alignment of the junction improvements, and again this issue of making sure that any development doesn't prejudice the delivery of the junction improvements. So it's the condition from page 13 of the council's appeal statement, and it states that any details shall safeguard all of the land required by the council to enable the delivery of Inshes Junction Improvements Phase 2 from any buildings, parking or servicing. And the layout required in terms of condition 2 shall be designed accordingly. Now it gives the reason to ensure that the development doesn't hinder the provision of the improvement project as shown in the Ragmore development brief and in Appendix 1 of the November 2021 committee report. What I noted that the wording of that condition doesn't indicate what land doesn't make clear what land the appellant is required to safeguard. So the equivalent condition in the existing permission refers to a drawing which shows the land that needs to be kept free for the delivery of the junction improvements. And while the reason refers to the development brief and the report of November 2021, as far as I can see, the alignment on these two documents is different. So I was just seeking views on whether the wording of condition 14 is sufficiently precise to ensure that the proposal wouldn't prejudice the delivery of the junction improvements? Are parties comfortable that they know what land is needed to ensure that that delivery takes place? Maybe turn to you first, Mr. Whelan.
Yeah, I'm actually going to defer to Gary here and appreciate that we don't have the benefit of his recent planning application drawing, which would give us that definitive boundary of what the land would require is. But Gary, you want to continue?
I think I'm satisfied that we're within the previous the previous land within the development brief is sufficient for us to develop what we're now planning. Is my take on it. We've stuck within that corridor.
Right. So if the wording of the condition referred to the development brief, then that would be sufficient. Mr. Pritchard, do you have a view on that?
I think it's definitely in the council's favour because they now don't need as much land. We haven't put forward any alternatives because we didn't want to get into that debate. There was obviously the plan in the previous appeal decision SK8TA, which was the larger area of land, particularly to the south. As you say, there's no plan within this procedure. And if Gary wants to stick to the phase 2 plan in the development brief, that's obviously the maximum amount of land that the council require. And we're outside of that. So we've worked out with that land anyway to date. So that's where we stand.
Okay. Mr. Smith, do you want to come back on?
Yes, I mean, we can confirm that through the planning application process that it has a red line boundary on it, but we can cross-check those two. But I think our brief was to keep within the that red line area, which is in the development brief.
Okay, it's just making sure that any condition in relation to this permission, if granted, is precise enough for people to understand what is required, and certainly it's more helpful if there's a map there that then allows that to provides clarity. But if I can cross-refer to the development brief and both parties are comfortable with that, then that should work fine. Okay, Mr. Smith, do you want your hand still up? Are you coming again?
Yeah, I just want to say is if it was helpful, we can provide a new plan for the actual land take, because as Mr. Pritchard said, the previous land take assumed a different scenario in terms of Transport Scotland's route into Inshes phase 2. So we could revise that plan in line with the planning application.
Is that different than the plan that's in the committee report of November 2021?
No, it's not.
So I could refer to that plan then as the most up to date. I'm just trying to, obviously, again, back to this sort of scenario for flexibility, because while we're talking about certain plans, there is still the potential that these plans could change, and you obviously need to make sure that it doesn't prejudice the delivery. So it's just being clear. I suppose it is almost that if there's a larger area, then that's probably wiser to be take a precautionary approach if that works for the appellant, rather than an exact line which may be subject to change. Mr. Pritchard.
So, I mean, we're quite happy, if you are, to work with Gary to give you a separate plan to go in that condition, because it did previously refer to a plan which was SK8TA, which has got the red hatching on it. If you're happy to insert a new plan into the condition, and as Gary says, there's a reduction. If you're happy, we could work with the council to provide a plan to go into that condition, if that's simpler.
If it works for both parties, I'm not going to come up with an alternative. It's really just it's making sure that the interests of both the council and the appellant, that something that doesn't cause you problems down the line if permission is granted.
But if it's within the SK80 plan, which I'm sure it will be from Gary's point of view, it's a smaller land take, so we're going to be happy with that, and it's more precise and it gives Gary what he requires to be reserved. Then we've accepted the condition in principle. It makes it more specific.
Okay, Mr. Whelan, do you have a view on that in terms of providing the flexibility if we go with a more prescriptive plan?
All I would say is that potentially backs Gary into a corner in terms of any future reiteration to the design that may deviate from what's lodged with the planning application. So from my perspective and from the council's perspective, it's better to have a larger area reserved and refine within that boundary. By having a refined in boundary to start with, any amendments then they fall out with that area. So Gary, over to you. It's your choice.
If the preferred approach goes forward, then the junction improvements would be developed first, and then everybody would know exactly where. So it's this covering every eventuality. Okay, I'll do you want to, if you come back with some, if the council want to consider whether there's a better plan to refer to than the one in the development brief or in the junction improvements, you could suggest that in your written submissions, and I would encourage you to discuss that informally with Mr. Pritchett beforehand, and then Mr. Pritchett, you would have the opportunity to let me know your comments in your closing submissions.
Yeah. Could I just say, I hear what Peter says, but as we all know, conditions have got to be reasonable. And if Gary's now got a different road plan, we can't just give more land than's required for what the proposal is at the moment. So I think that for both parties, we're better off devising a plan which is based on the road proposals that are coming forward. I think that gives us all the best position that we'll be in just now, rather than referring to a brief which is not now up to date and going forward.
I think it's a balance between updating but future proofing. You don't want it to be so exact that it doesn't allow for which would then prejudice the delivery of the scheme. So if between parties they can you can come up with something that works, then I'd be happy for you to share that with me. Okay, right. I think that's us finished with matter 2 on the junction improvements. To say, apart from discussing the potential need for contributions towards it. If we in moving on to matter 3, there's a few documents that would probably be useful if you had in front of you, and maybe give you a few minutes to, if you don't have those. So I think we'll need to discuss the original transport assessment, the supplementary transport assessment, policy 31 in the Highland-wide local development plan, the supplementary guidance on developer contributions, document 35, which is the Inverness East development brief, and the planning circular on planning obligations and good neighbour agreements. Now, I realise that circular hasn't been lodged, but hopefully, if you don't have, you can get a copy off the internet if you need to have it to hand. So if I can just take a few minutes, I'll get these documents up, and if you could do so, then it'll hopefully speed things up as we get into the discussions. Are there any other documents that people are likely to refer to, definitely, that we should access? Nothing? Okay. Doesn't stop me referring to them, but if you knew in advance, that would be helpful. Everybody? What they need in front of them? So don't worry if you haven't. We can take a pause. It's more important that you have what you need. So matter 3 relates to developer contributions towards transport infrastructure and improvements. The council seeking £1,992,497 index linked from Q7 2017 towards transport infrastructure. It's referred to the Inverness East Development Brief as providing the justification for the required contribution. I would like to consider the contributions towards transport infrastructure in 2 parts. So first of all, the wider Inshes corridor improvements and East Link, and secondly, potential contributions to the Inshes Junction improvement phase 2 works. If that's okay. Again, there may be some overlap, but in my mind, those are two things that I need to address, whether there's a justification towards seeking financial or otherwise contributions towards these. So if we turn firstly to the request for wider contributions of the nearly 2 million. The Highland-wide Local Development Plan Policy 31 on developer contributions sets out the development plan context for seeking contributions and indicates that the principles that guide the preparation of developer contributions being supplementary guidance. In that guidance, it says that the contributions for all development on sites allocated. Sorry, I'll just get the document. Yeah, principles that guide the preparation of the guidance are fair and proportionate contributions. Contributions sought where a need for new or improved services and infrastructure have been identified, and talked about flexibility of approach to ensure development can be brought forward. So what I wanted to really look at within the context of the local development plan and the supplementary guidance, trying to understand where the justification for the required developer contributions come from, and really looking back in terms of what the transport assessment says in terms of the impact of this development on the network. And I asked the appellant to lodge the initial transport assessment, because obviously what was submitted with the application was supplementary to that. So I've now got both of those documents, but so the first question, does the initial transport assessment identify the need for mitigation other than at the Inshes roundabout? The council or Mr. Latto maybe wants to come in first.
Yes, the initial. Yes, the 2013 TA identified that the only impact was at the Inshes roundabout, and that it identified a level of mitigation to compensate for that.
I understand that there isn't, the existing permission doesn't have a requirement towards wider transport infrastructure. Is that correct?
No, it was quite clear through the agreement, through the previous appeal, that the no net detriment mitigation was only at the Inshes roundabout.
Okay. The council's point of view, is there anything within the original transport assessment that I should be looking at to justify impact on the wider transport? network.
Defer to Mark if that's okay.
Yes, please. Mr. Clough.
Yes, sorry. I had a look through that information as well for the first time in reviewing this application and then preparing for the appeal. And it appears, at least anyway, that the assessment work that was done in the original transport assessment had 2 sets of trip generation information within it. And I think that was off the back of that the promoter or the appellant had proposed using trip rates from that had been used previously at the Inshes retail park development and developments that had happened in that site. And the council had rejected those as trip rates because those trip rates in the Inshes retail park were geared specifically on the fact that there's a real opportunity for linked trips within the park itself. So you can drive or walk from the far south end of the retail park and get to the north at Tesco's without even touching the public road network at all. Whereas obviously this site is slightly remote, and the fact that the buildings are put at the back of the site makes it even more remote from the existing retail park with public road between. So I think the council transport officer at that time had said that new trip rates needed to be justified in any assessment submitted. So it appears that the appellant continued with the Inshes retail park trip rates, but also then did something called, I think, a sensitivity test within the original transport assessment, where they generated their own trip rates for proposals within the site, and they came out relatively higher, and they've done the assessment on both of those and within the original TA. So it's just to be aware at this stage, before we get into any more detail, that there are 2 different trip rates that have been included in that transport assessment.
Okay, Mr. Latto, you want to come in on that point? We'll take this in sort of bite-sized chunks,
Yes,
if you don't mind.
Thank you, reporter. Yes, I've come back. Mr. Clough's right. The original TA undertook a sensitivity test. We didn't agree with the council's position, and I'll come back to that. But the assessment within that TA again showed that there was no wider impact apart from on the Inshes roundabout. So that was the clear conclusion of that report. In regard to there's been a lot of noise over the many years that this study's been going on about the traffic generation rates. It's from an industry standard TRIX database, which the council use, and I'm sure the council may be relying on within their own modelling for the wider road network. We have applied a trip rate for retail park with food store or superstore, which is robust because what's actually been approved is retail park without food. So actually the trip rates we've applied are completely independent, if you like, of the Inshes retail park, because even if we agreed with the council, which we don't, that the Dell of Inshes is wholly separated from the Inshes retail park. It's even if it's independent, those trip rates are robust because they include a food element within the traffic generation. So we are more than content that we have applied the industry standard applications in a very robust manner.
Okay, that's helpful looking at the initial transport assessment, and obviously we have the appeal decision based on that. Obviously, when this application came in, there's a supplementary transport assessment. Does it provide any relevant information for me to look at in terms of impact of development on the wider corridor and the East Link? And did the council ask, if the council wasn't satisfied with the previous transport assessment, did it ask for something further in relation to this application?
Well, I think the council's response to you was no, they didn't ask for more information. The agreement and the approval was on the basis that the council accepted there was no other works or impact required apart from the Inshes roundabout under the no net detriment solution. So they withdrew their objection at the appeal on that basis. They helped draft the conditions and they agreed to it. So there's nothing fundamentally changed from that point to this point, because at the point of approval previously, the East Link and the Phase 2 works were well known about through the Inshes and Raigmore development brief. So there's nothing new, since 2016-17.
Okay. I think we'll come back. I'm sorry, we'll break it into bite-sized, because certainly in policy terms, we obviously have the Inverness East Development Brief. So there are things that have happened. It's just trying to establish what relevance and what weight to give to them. And I suppose I'm trying with the starting point to understand that the council's policy leads me to to look at a transport assessment to identify the impact that development will have on the wider network, which would be the justification for contributions or for delivering improvements. So I'm just trying to follow through the stages. So yes. Mr. Whelan or one of the Mr. Clough, can you help me with the supplementary transport assessment as to where I should look at as to what was asked for that's different and that would provide more up-to-date information from what was in the initial transport assessment?
Sorry, bear with me. Now, my understanding is that I don't think we got a heads up that the extension application was coming in with any sort of scoping exercise for the any TA works that might be coming in with that. Certainly not in the transport planning team. I don't know whether the planners did, but that is so we. Certainly the transport plan, I don't think we had the opportunity to provide advice on what the scope of any subsequent assessment work might well be needed for this renewal application that's currently in.
You would have had the opportunity when the application came in. You would have been consulted on it. So I suppose there would have been a consultation response if there was information missing. Would that have been a time that you would have flagged that up?
Yes, we have obviously reviewed the information that came forward with the application, and our feedback is as laid out with the documents that have been provided with the application in the appeal. But our focus was mostly on the demonstration of the requirements of the original appeal decision, if you like, which was around the access, the no net detriment aspects of impacts in and around the Inshes roundabout junction, and the non-car connectivity issues, particularly linking in with the other commercial areas and developments in the area.
I suppose at that time, in the original appeal decision, there wasn't a request for developer contributions towards the wider network, so it maybe didn't flag up. Mr. Pritchett, do you want to come in on that?
Yeah, just so that you're aware, we did have a pre-application discussion with the head of planning, Malcolm McLeod, the South team leader, David Moody, and it was agreed with those officers. I don't know who they spoke to internally, but it was agreed that we just needed to do a supplementary TA to update the previous study, and that's why we lodged that on that basis. As I say, I don't know what internal discussions were ongoing, but we lodged what we were requested to lodge with the application.
Okay. Anybody want to direct me to anything else in either of those TAs, or we move on to, I suppose, the implications of that is looking at where that requirement for the wider contribution sits in relation to the tests and the circular. Mr. Latto.
I would direct you, reporter.
Getting two of you again.
Yeah, I direct you to Appendix A, Figure 10 of the 2013 TA. That indicates the predicted traffic generation of the development, and that includes at the Inshes retail, at the Inshes roundabout. And if you add up the net predicted increase on Culloden Road to the east of the Inshes roundabout, heading towards the A9 and the Eastlink, there's an increase of 42 vehicles during the PM peak, which is negligible. And again, that gives you the scale of the impact and the additional traffic associated with this development.
Okay, that's helpful. Mr. Clough?
Thank you. Yeah, I was just going to raise a similar point to Mr. Latto, that it's image 10 from Appendix A, which shows the predicted trip generations from using the Inshes retail park trip generations for this development, which is, as Latto pointed out, I think that drawing shows 41 heading towards the Inshes roundabout and 26 heading away from Inshes roundabout on Culloden Road towards the A9 and from the A9. But just to point out as well that when Mr. Latto pointed out about the robustness of the trip generations that were produced specifically for that transport assessment, whilst they did base themselves on a retail provision, they didn't account for the smaller retail units within that master plan development. So it was purely for the larger retail. There was a suggestion that the smaller retail units were, just to get the wording, I think were directly affiliated or would be affiliated with the larger retail unit, which we didn't think would be the case. You know, there might be an element of shared trips between the larger retail one and the smaller retail units, but those retail units should be recognised to some degree in generating their own visitors to and from them, rather than just completely ignoring them as a generator.
So does the council have a view on what trips would be generated from this development? If I can't rely on what's in the transport assessment, what should I be looking at in terms of impact?
I have to confess, I did a bit of a fag packet calculation as part of this. So, as was, I think has been pointed out already in the appellant's submission, that if you use just the original Inshes retail park TA trip rates, you get, I think, something like a 3.5% increase in traffic on Culloden Road and a 4.2% increase on Old Perth Road, which is on the western side of the Inshes roundabout. If you then did the same calculation using the trip rates that were included as a sensitivity test in the transport assessment, then you get something like a 6% increase on Culloden Road and a 7% increase on Old Perth Road. These are over the base trip rates. I should make the
That's
point
what I was
of
just
that.
going to ask. What's the percentage?
Yeah, it's over the base trip rates that are shown in the original transport assessment. So those are the observed trips plus the trips from committed developments that were recognised in the transport assessment. But then if you assume that, say, half the square floor area of the smaller retail units were generating their own trips, so half were independently generated trips and half were linked trips with the larger unit, then you get roughly a 7% increase on Old Perth, Culloden Road, and an roughly 8.3% increase on Old Perth Road, if that makes sense.
Some of the figures, I suppose, what I'm struggling to compare, I've got the appellant has given me figures in terms of peak vehicle generation, and you're giving me percentages. So how do I
Oh,
Just we'll
okay.
compare those in terms of what they mean when measured in the same currency.
Okay, so if you're looking at trip numbers, then so that final one, the sensitivity test that was included in the TA plus 50% for the smaller retail units, then you're looking at development trips westbound on Culloden Road of 78 trips and eastbound 55, so that comes to a total of 133 trips. And if you're looking at Old Perth Road, I think I worked it out roughly as westbound on Old Perth Road 47, eastbound on Old Perth Road 70, so that comes to 117. Let's say that was a quick fact packet calculation prior to the meeting today. It can certainly be checked and followed up on if required.
Okay, well, obviously, this is the first time that we've had that evidence, although I understand that Mr. Pritchett has been asking for it. Mr. Latto, do you want to come back on that evidence from the council?
Thank you, reporter. I'll try and unpick. Appreciate that Mark's done his back of fag packet calcs there, and this is the first time we've heard them. Unpicking part of that, you're right to note that we have been asking the council, what trip generation and distribution is it relying on in regard to its forthcoming planning application for the strategic roads. We haven't had a response on that. And again, I'm sure they would have used tricks. Even assuming Mark's worst case scenario, which assumes that each of these units is an individual standalone unit, which is not the way that you apply the industry standard tricks database. Even assuming that, we're looking at, instead of less than one vehicle a minute, to maybe circa three vehicles a minute. Now that assumes no existing traffic on these arterial routes will drop into this retail park as part of their existing trip. It assumes they're all new, and all the rest of it. So even assuming all of that, and again, I'd be very interested to see what the council will be relying upon if it wishes to do so. The net difference is not material. It certainly wouldn't be impacting on the wider network. That was accepted by Transport Scotland on all the applications. They do not believe this development will impact on their trunk road network, which sits adjacent to Culloden Road. I think the quantum won't be far off. I think that the impact won't be far off, and it certainly isn't as wide-ranging as suggested.
I'll make a decision sort of after we've gone through this whether or not I need to take these figures formally and seek views on it. But for now, that's helpful. Mr. Pritchett.
So I don't know whether it's the right time to make this point, but if this is in relation to assessing traffic impact to see whether the 1.9+ million is appropriate, I think, as Mr. Latto has said, and what I would refer to is that wasn't the reasoning put in the committee report. The committee report was based on a formula in the East Inverness development brief. So I think I put this in my submissions, is that we seem to be retrofitting a justification for monies to be paid based on traffic impact. And I think we've heard from Mr. Clough there that we're still at very small levels of traffic, but I think if it's the right time, that's not what the report to committee actually stated. So that's what I was making my point on in our original submissions. And I don't know whether we're going to come into this, but it's whether it's even relevant to be asking for those monies rather than trying to assess figures. So we may come on to that later, I'm not sure.
Yeah, I say if we can keep going through with the various bits of evidence. I was keen to understand what was in the transport assessments. Say some of the evidence that's come out now seems to be beyond what was in the assessments, and because I want to sort of pull back to and look at the Inverness East brief as well, because my understanding is that the justification for the figure that was required by the council has come from applying the standard requirement in the Inverness brief. So I agree with Mr. Pritchard that we've kind of come up with an alternative mechanism that certainly hasn't been before me in terms of the council's consideration of the application. I'll reserve judgment in terms of what I do with that at the end, but I'd like to kind of, I suppose, move on to part B, which is within the context of the tests in the circular. And looking at the supplementary guidance and development contributions and the Inverness East brief, which is what the council has referred me to as it's providing the justification. Where can I find the evidence that would link back to the tests of the circular in terms of that level of contribution being necessary and relating to the development? So if we put aside the kind of the figures that Mr. Clough's put forward and just have a look at how the justification from the Inverness East brief and the SG relates to the tests in the circular. I understand I kind of just printed off a little map from the East brief. I mean, I think we're all in agreement that the site lies out with the boundary of the brief. And again, correct me if I'm wrong on any of this. What the brief did was looked at the development that is proposed within the boundaries of the brief and assessed the transport impact of those in terms of the Inshes Road corridor and the East Link, and then calculated a formula for proportionally distributing that across the development within that area. And I think Mr. Pritchard's pointed out in his evidence that this proposal doesn't form part of the development that's been calculated, nor does it rely within the boundary. So I suppose what I'm looking to the council is to direct me to where I can find the justification for applying that formula to a site that's and a proposal that doesn't form part of that. Mr. Whelan, are you able to assist?
That's fine. I'll come in to try and explain a little bit of the changes that have taken place since the last appeal decision. So I'll refer you back to the committee report of handling, paragraph 8.4 onwards. It really explains the progress that's been made in terms of the council's development plan. We have a new adopted developer contribution supplementary guidance document that looks to assess development impact on the strategic road network as a whole. So not just specifically one roundabout, but as a whole. We then look at defining contribution rates within specific development brief areas. And adjacent to this site, almost equidistant, if you like, on the other side of Culloden Road, we've got significant areas of land allocated for development in the Inverness East development brief, with that brief having been adopted since the appeal decision has taken its place as well. And what that brief looked at was how much infrastructure would be required to service development within that area. And bearing in mind that the infrastructure proposed within that area wouldn't just serve development sites within that area, 50% would also serve other parts of the city. So from development sites out with the brief area and for existing residents and land uses out with that brief area, they would also use that network as well. Looking at
sorry, is that mentioned in the brief about this assumption that 50% would?
it is, yeah. So in the development brief, it says that the costs of the infrastructure assume only 50% of the trips from the land uses in the Inverness East Development Brief area would use Eastlink and from Inshes roundabout, and therefore the other 50% of the infrastructure cost would be borne by the Highland Council or Transport Scotland or the taxpayers as a whole. So 50% borne by the cost of development within that brief area and 50% borne by the state, if you like, to keep it simple. That equated to a cost, as said in the brief, and is divided then by the mix of land uses proposed in that brief area to get a rate per house and a rate per square metre of employment, land use or retail. Now, we didn't have sight of that at the last appeal decision. We didn't know what contribution rates were in the vicinity of this infrastructure. So this particular appeal site has a direct link to Inshes corridor. That link needs to be substantially improved to facilitate this development site taking place. It's also the case that trips from this development have been factored into the design for Inshes corridor as well, and into the design for Eastlink as well. So we knew the trip rates and we modelled them, and we created a plan in terms of what infrastructure requirements would be for that area. That includes Inshes corridor and Eastlink. Looking at the trip information that has been discussed at the head of this conversation, it's evident that trips will be generated towards the roundabout, but it will also be generated to and from Eastlink. Point me if I'm wrong. I'm happy to revisit that if anyone disagrees that trips to and from this site would go via the roundabout and would also go via the Eastlink proposals as well. It's important to look at the Eastlink proposals as a whole. They also include things like an extra slip line on the A9, for example, and that is immediately in the vicinity of this development site too. So we've got a whole raft of new information since the last appeal decision was taking place, and given that we're out with the brief area in terms of the Inverness East brief area, I thought it would be logical and proportionate to distribute the same costs on one side of the infrastructure works as the other. And therefore, there's a logic to say if you're joining that infrastructure works from one side of the road and from the other side of the road, that they should be paying the same rate. I was looking back to other windfall development sites out with the brief area to see if this approach has been applied previously, and it has been. I noted that you were the appointed reporter that looked at the Springfield development site that was just to the south of Simpson's Garden Centre as well, where the developer and the council sought contributions. Well, the council sought contributions towards Eastlink and Inshes corridor. And I can give you the reference numbers, but you'll have all that information to hand, where developers out with the brief area were willing to contribute towards that infrastructure on the basis that trips to and from their development site would be going through those pinch points on the network where there isn't capacity at present. Lack of capacity is evidenced by the last appeal decision on the requirement for no net detriment, and therefore, on the basis of that information, I didn't foresee this to be a reason for the council to refuse planning permission on the site, providing that suitable developer contributions were forthcoming to mitigate the impacts of this development. And at present, the current permission, if renewed without any amended conditions, would allow the developer to effectively sit, wait. Council would do all the interventions, build out all the infrastructure, and the developer would simply connect in and not have to put the hand in their pocket at all. And in fact, we need to CPO their land as well to enable the council to deliver that infrastructure. So I think it's a fair and proportionate way forward, and how that sits against the test in the circular, I think we can, we'll have to go through.
Yeah, we'll do that. Thank you. That's helpful. That certainly increased my understanding of how you got to that figure. I have a couple of questions or clarifications. So, in terms of the development brief, is it really that this site would contribute to the other 50%? So what you're saying is that 50% would be of the overall costs of the infrastructure are to be met by development within the Inverness East site, and that sites out with would help contribute to the 50% that's been picked up by the public purse. Is that the?
In reality, I don't think we're ever going to get 50% of the cost back for the infrastructure.
No, but contributing towards what? I just think that
there'll be other
the
development
calculation,
sites and other.
this site hasn't been counted within the development mix in terms of what the formula for the Inverness East brief. So it's difficult to align this contribution to that. But I think from what you've said, that there's further costs that won't be met from the development within the Inverness East development brief, and that it would be reasonable to seek contributions from this development towards that. Is that a fair summary?
That's a fair summary. I would also point out that the council's accrued 1.4 million from other development sites like with Inverness East development brief area towards the Inshes phase 2 works specifically.
And have any of those been disputed by the applicant or an appellant? Are there others? Are there other appeal decisions? Are there other applications which I should be looking at where developers have questioned the approach?
You could look at the recent housing permissions that have been issued across the south of Inverness, but they haven't been challenged at appeal level, and the contribution rates haven't been identical to those in the Inverness East development brief, principally because they were sitting in other development brief areas where extant rates were set. So on those occasions, we thought it'd be best to stick with the existing adopted rates for those housing sites which are more removed and more distant from the interventions that are being planned as well.
I think just to clarify, so you said you didn't think that this was a reason for refusal. At what point was the appellant aware that the council was going to be seeking this level of contributions? Was it something that was discussed during the planning application process, or?
The precise quantum wouldn't have been known to the developer until the point where the committee report was made public. So they could have raised that ahead of the committee decision on the application should they wish to have done so. The need for
is that normal? Is that normal approach of the council? I just think, again, going back to your supplementary guidance on developer contributions, and there is a statement about viability, but if an applicant doesn't know that the level of contributions that's going to be requested of it until it goes to committee, then how would they know to put in indicate that it would have implications for the viability of the development?
It's interesting, you're correct. In normal circumstances where we're in a position to support an application, we will set out exactly what the developer contribution ask would be to the applicant, so they're aware of that well in advance of committee, and so that we could discuss that. In this scenario, we were minded to refuse the application, and the figures set out in the report are on the basis that if members were minded to approve the application, that we had a position in which we could seek developer contributions in the event that that decision went in favour of the developer on the day. I appreciate those figures should have been shared in advance, but in terms of viability, I would question the need for any viability assessment. If you look at the information in the retail impact assessment, it's pretty clear what the turnover would be for this development year on year. We're dealing with the highest land use value in retail, and the contribution in relation to annual turnover for this development is something to be considered. I'll let Mr. Pritchard come in.
Okay, thanks, Mr. Whelan. Mr. Pritchard, quite a bit there, obviously, for you to comment on.
Yeah, we did we did have sight of the 1.9 million. It was in the it's in my document, document 23. I think it was the development plans team that had responded, and I responded in the process. I pretty much stand by everything that I've said previously, and I've not heard anything really that I would change our opinion on. In that we think this is a case of LSIC, in that I think Mr. Whelan quoted that this is a strategic transport fund. I don't think, in my experience, that is justifiable, as the starting point is it must be related in scale and kind to the development proposed. And I have thought, and I'm sure you will find on this, that in order for a contribution to be justified, it needs to be related in scale and kind. As a related figure, on South Inshes in 2017, we had consent for 10,000 square metres of retail floor space, including an element of food, and the contribution was £100,000. That actually, I'm not sure whether Mr. Whelan knows, is included in the 1.4 million that the council has gathered towards Inshes roundabout. The Aldi development paid £16,000, and that's 1,600 square metre store, and then the Aldi extension paid £0 to Inshes roundabout. So we're finding it quite difficult. We're not saying we'll pay nothing. We're saying we need to pay legally a figure which is related in scale and kind to the development proposed, and that needs to be related back to impact. I think as Mr. Clough has calculated in his back of his fag packet, and Craig Latto has done, there are thousands of vehicles, and I think in the latest submissions that the council has submitted, something like 11,000 vehicles along the Culloden Road corridor. We're talking about 42 vehicles at the peak hour increase along Culloden Road. Again, I think in our submissions, we've been asking the council for many, many years as to what they calculate this site as contributing in terms of traffic. We've never seen any figures that the council have come up with. We think they've used the TRIX database, which we've used. And the TRIX database shows that in the peak hour, there is actually a low level of traffic, circa, it's either 1 a minute or maximum 2 a minute in the peak hour. We cannot see how that can get anywhere near £1.9 million of a contribution. So whichever way you look at this, I'm afraid our submissions suggest that you can't get anywhere near that figure. And we actually think, and there's nothing wrong with this, we actually think it's a calculation in the East Inverness development brief based on what was expected in that brief area, which is neighbourhood shops. There are neighbourhood shops identified in East Inverness. There's a figure of £1 per square foot for that retail floor space that will contribute, and that's absolutely fine. I don't think, and this is a guess, a calculated guess, I don't think that rate per square foot in that brief was ever designed to cater for something like 5,000 square metres of floor space at Inshes. I know that Lidl are having the same debate with the council at the moment on a site not too far away. So I've not seen anything in the evidence to see how you get to 1.9 million. That's where we stand.
Thank you, Mr. Pritchett. I suppose just in a follow-up to that, one of the things in the paragraph 3.3 of the appellant's hearing statement was where we stated that the transport contribution for the proposal equated to over 9% of the total 50% requirement, and you compared the floor space of your proposal to the 3,000 houses and 23.6 hectares of employment land. And I think you said that even if a payment was due, it's not at that level. Is the council able to comment on that? Because it would help me to understand, because I think it's a fair point that that's been made in terms of the level of contribution.
The level of contribution derived within the Inverness East development brief area, you'll note that in terms of floor space is particularly high in terms of retail. The cost is much higher for retail development. The reason for that is based on TRIC database trip generation. So that's why.
And is that trip? Would that apply to the trip generation for the appeal proposal? Because I understand that the appellant has used tricks to generate the figures. So
the same
you're
methodology
applying it to the number of vehicles, not the impact on the network. Is that?
It's applied based on trip generation from retail floor space.
You still think that's a reasonable amount to seek from? Is it worth me sending the two parties away to have a discussion about or is it something that there could be potential agreement on, or am I better just taking note and saying, well, the council say this, and just taking that?
I would look at the costs associated with finding the no net detriment solution for the applicant here. So if the council didn't come forward with Inshes phase 2 works, how much would it cost for the works the applicant requires to serve and enable this development? We're putting in a high capacity roundabout. We're putting in a new overbridge to link to the A9. I'm pretty sure the costs associated with those works has been shared with the applicant already. Gary, correct me if I'm wrong, is that figure around about £2 million?
You able to help, Mr. Smith?
For the Inshes retail park access, yep, 1.8 million.
1.8 million isolation.
Yep. Obviously additional works for the A9 overbridge, but
the A9 overbridge, where does that sit? Does that sit in the Inverness East development brief?
Yes, that sits with Transport Scotland.
Sorry, can I just clarify where that 1.8, so that's what the council considers the no net detriment solution would cost?
That's the access to the Inshes retail park from Culloden Road.
As part of the Inshes improvement project, or if the appellant was doing an access itself from the...
Either or, if you built it in isolation, that's its cost.
Right.
And is there any land value also in that figure, Gary, or is that purely on construction cost alone?
That's construction cost.
So we have the land value to account for that as well on top. So at the moment, we don't have the land. We need to purchase that from the applicant in this case as well. So 1.8 plus the land value.
Okay. I think what I would like to do, and we may go over around, is just basically go through the tests in the circular, and if both parties could kind of point me to where the evidence is that that I would find that the contribution would be justified. So the first one is necessary to make the proposed development acceptable in planning terms. So this is obviously the contribution to the wider network. Mr. Whelan, I think we're going to have to start with the council first on these.
No, I mean, I would refer you back to the committee report in terms of the general approach to developer contributions. In terms of being necessary to make the proposed development acceptable, it was pretty clear from the last decision was made that a no net detriment solution was was the position in terms of
The last
solution
the
that's
last
come
decision
forward?
didn't require contributions to the wider
No, it didn't.
network.
It
So
didn't
there
have
must
the
be some
information. Yeah, available to what the interventions would be to the wider network. So now we have a costed scheme for Eastlink. We know what area that development will serve, and we know by building out Inverness to the east, that Eastlink will serve as a direct connection to and from this side. So this development will put trips on Eastlink network and the overbridge over the A9 and the slip road that's with the A9
Do
as
we
well.
know how many trips it'll put onto the Eastlink?
I'll be guided by Mark's calculation or the applicant's TA in that regard in terms of the number of trips.
We never really got as far as that because we took it as far as Culloden Road, but obviously, you know, there must be other assumptions. You're on mute, Mr. Lato. If you want to come in.
I can feel could go off there. Yeah, I think would it be helpful to the reporter if the council, through its modelling consultant, actually confirmed the traffic generation and distribution of the Dell of Inshes development traffic, and that would absolutely indicate the volume and distribution on the routing of that development traffic. You know, and everyone could then take a view. You know, there's been many figures, many suggestions. I mean, yes, no, you know, if the Eastlink is built, traffic linked to the Dell of Inshes will use it. But if the Eastlink is not built, it won't use it. It will use the A9, and Transport Scotland have already said there's no impact there. So I just wonder if it's helpful for the reporter if the council could simply provide that information.
Is that something that the council is able to provide?
Gary, do you have that information?
I've all through this process, I've given the developer free access to the traffic consultant through, or Jacobs is our traffic consultant for the Inshes Phase 2, and as I understand it, they have exchanged lots of information between each other in terms of what we've been modelling and why and how. But I could get a breakdown of that from our consultant.
Certainly, I think. I mean, at the minute, as far as I can see, I've got two parties with different, potentially different figures, and I'd like to think that if there's two transport consultants working on it from a standard base, that, you know, it would be helpful at least to see where there is agreement, and then what we do with those figures. I suppose there'll be a difference of opinion as to what that means for this proposal. But I'm coming around to thinking that we will need that, because otherwise we're just going to fall at the first hurdle that we don't know.
As far as I know, there is no dispute between Jacobs and Mr. Lato in terms of the impact of traffic on the model and the contribution of the traffic to the model.
My understanding from what had been said was that the council didn't agree with the figures that were used in the initial transport assessment, and that the appellant hasn't been able to get hold of the figures that the council has used. Is that?
I have given permission for Jacobs to release all of the figures that we have, and I think they've exchanged model information from the model that we created for the east side of Inverness.
Mr. Pritchett, do you want to come in? Can anybody help me through this maze?
Yeah, I think we need to be careful in that Mr. Whelan and the council, quite rightly, are planning for the growth of Inverness. And they're planning for the Eastlink to expand the city of Inverness. They've been withholding doing any works at Inshes Roundabout for the best part of 20 years, notwithstanding two slip roads that they put in. That's been absolutely fine you know, in terms of the way in which they wanted to approach things. But what that has meant is that this corridor has been constrained for quite some time because the council has not improved it. As Mr. Whelan says, the council's had £1.4 million, I think, for the best part of 10 years. It has decided not to spend the money because it wanted to do a comprehensive improvement to Inshes roundabout. The appellant here gave monies 7 years ago to Inshes roundabout. The monies weren't spent. So I think the concern that I have is the council have been constraining this corridor for quite some time because it's wanted to do a comprehensive improvement. So my concern is we've been coming at it from a normal development management point of view, is what is the impact of our development and what is the no net detriment solution that we get to? And we've never got to a point whereby the council has accepted there is a no net detriment solution, because the council has been focusing, from its point of view, quite rightly, on wider improvements to the network. But there have been consents granted all around here for developments just paying reasonable contributions to roadworks based on no net detriment. So I'm quite concerned that we haven't been refused planning permission based on traffic impact. We've been refused planning permission on flooding and retail impact grounds on the city centre. I'm concerned that we're now getting into a traffic impact issue based on the fact that the council is seeking a contribution of £1.9 million, which in the report to committee was based on a formula, and as Mr. Whelan has said, about strategic network improvements to facilitate growth that the council is looking to implement, which is fine. But I'm getting quite concerned that we're dealing with something which is not about a scale and kind contribution to mitigate the impact of this development, which, as we've discussed today, are very small traffic movements anywhere outside the Inshes roundabout itself. So we'd quite like to get to the conclusion of this proposal as quickly as possible and as simply as possible. I'm getting concerned that we're now going to go into a traffic impact debate, which we weren't refused planning permission on. So sorry for being long-winded, but it's quite important that we're getting into figures which we've not really discussed at all during this process.
I hear your concerns, Mr. Pritchett. The difficulty I have is if planning permission is granted, then it's through the use of conditions and the developer contributions that may make a development acceptable. And if a condition or a contribution cannot be, if a contribution cannot be agreed and cannot be found, then it's almost that potentially becomes a reason for refusal. So I can kind of understand why the council didn't include it as a reason for refusal if it was assuming that that contribution that it considers to be necessary was to be paid. It's in looking at detail at the level of contribution and whether or not it meets the test of the circular that I need to consider. And so I say I can appreciate it wasn't a reason for refusal, but it is a matter that has been raised by the appellant as being something that you wouldn't be able to accept if I granted planning permission in principle in line with what the council has said that it requires. So we've got to tease it out one way or another, and it's just trying to work how to do it in a fair and proportionate way. And again, we come back to being guided by what's in the circular, which is what I'll need to take a view on in terms of, one option to me is that I consider the principle of it, and then I send the parties away with the intentions notice and you battle it out amongst yourselves in terms of what that level of contribution should be, or is it something that we need to thrash out in advance of any decision, and that's where I'm basically trying to gather the evidence that I have. I can take stock now and say, well, I need to make a decision on what's in front of me, and I don't have these additional figures in front of me at the minute, and I may not get, you know, that agreement. It's really just trying to tease how far we should go on this. Your thoughts, Mr. Whelan?
Sorry, just one, and I think you have a very hard task, but I think what would be very helpful, and I didn't mean to labour the point about the figures, but it would just be extremely helpful to the appellant if we had the very specific figures that the council is modelling, that is the traffic generation that it is modelling for the Dell of Inshes site. I think that would go a very long way to helping us all out to see if there is any impact that we need to mitigate. So I think if there's a direction, then it's to the council to provide those figures as soon as possible, then I think we'll be a long way forward.
The council, I mean, what we could do following today is that I request that the council provide those figures and seek their opinions on the implications of them, and then give the Mr. Pritchett and Mr. Gordon, if he wishes, the opportunity to comment on those. What we don't know is where that will then take us. I don't want to go into rounds and rounds of further written submissions, because we could, you know, at some point we need to draw the line, and I need to make a decision based on the information that's before me. But if the council and the appellant think it's worth taking the time to look into that, then I'm comfortable that may help.
I'm conscious of what benefit that's going to drive. Essentially, what I'll show you is distribution of trips from this site in relation to how many vehicles are already on the network. We know that already the access arrangements for the site will go directly onto the network. They'll be over and above the current position, which is deemed to be unacceptable without further mitigation. So say it's 10 more trips per hour, or it's 15.
I think where I would find it useful is in relation to the tests of the circular, about it being fairly and reasonably relating in scale and kind. You know, I think it's from what I can understand from the appellant, that the principle of making a contribution beyond the roundabout may be acceptable to them. It's the level of contribution that they're struggling with, and I suppose what I need to understand is, does that level of where's the evidence that suggests that level of contribution is fairly and reasonably relating scale and kind of development.
But I think we're costing the wrong thing then. I think what we need to look at is how much the intervention would be to facilitate development of this site. And that should be the amount of contribution towards the Inshes Phase 2 works. I'm not saying they pay for all of Inshes Phase 2 works at all. What I'm saying is we need to cost the fallback position of Inshes Phase 2 works.
But at the minute, what we're talking about is contributions to the wider infrastructure, not the contribution to the Inshes 2 project, which we still need to come on to.
Okay. The two projects are interrelated, though, in terms of the flows and how they've been modelled and what's been designed. So I'm just keeping that in the back of my mind. I've also got some updated figures from Gary in terms of the overall cost of Phase 2 works as well. So the committee reported that at 6.7 million.
6.7 million was the cost of the Inshes, right? That was the Inshes
Phase 2 works.
That was the capital allocation at the time. Not the,
But the current cost estimate now stands at 8.5 million.
that's correct.
And where does that factor in if the land value? Do you deduct that if you were costing it to the appellant, would you deduct the land if because they obviously own the land? Is
As it
is the
stands,
land a contribution in kind that then comes off the overall figure?
as it stands, we don't know what the land value will be. The contribution amount assumes that we'll have to purchase the land from the applicant to deliver the works. So if it was say 2 million, say, at the point of writing the committee report used in Q4 2017, I checked the indexation figures to see how things have compared since. So now we're at Q3 2022. So that 2 million figure now stands at 2.3 based on current values, which is an increase of about 15.5%. The Inshes Phase 2 costs have gone up 30%.
13 or 30?
30.
30. That's from 6.7 to 8.5.
6.7 to 8.5. And we obviously don't have an updated cost estimate for Eastlink from Transport Scotland, who will be building it out and then passing it back to the council to maintain thereafter as a council adopted road.
I think what we might do is I'll seek the views of the appellant in terms of the test of the circular, and then I think I'll maybe take stock after today and think about how I want to proceed. I think it's right to be cautious because we could end up opening a can of worms that takes us in various directions that doesn't actually bring me any closer to finding a definitive answer, and I'm going to have to make a judgment on it regardless. So I think it's difficult to sort of take all of that in a hearing scenario. So if it's okay with parties, I'll kind of take stock after today and follow up with what I think I need to go further. But before I finish it, I'd like Mr. Pritchett. Can you give me the views of the appellant just for clarification on how that contribution of 2 million fits with the tests in the circular? You're still on mute, sorry.
So I think the appellant's position is, as we've stated in submissions, is that we don't think the 1.9 million is related in scale and kind. We have put forward evidence to suggest what the impact is. And as far as we're concerned, is the tests in development management purposes is you mitigate the impact of the development. The role of the development management system is not to create betterment, and it would be unlawful for the council to seek monies which go over and above mitigating the impact of the development. The evidence that I think you have suggests that the transportation impacts of this development are quite constrained around the Inshes roundabout, the immediate surroundings on the Culloden Road corridor. I haven't seen any evidence from the council to suggest that there are wider impacts, and I think this is the debate we're having here, is the wider impacts. Mr. Whelan is talking about the council's proposals for accessing a very large Inverness extension of the city. That is not the same as mitigating our impacts. And I think from our point of view, it doesn't pass the tests of being necessary, related in scale and kind to the development proposed, which we think has very localized impacts. And unless you have before you a detailed assessment of those impacts from the council's point of view, our submission is that you simply can't find that 1.9 million is justified. And just the final point is it seems to me that the only two differences since the appeal decision was, I think there's the supplementary planning guidance and the East Inverness development brief. And we don't think that the East Inverness development brief is either at all or certainly sufficiently related to this development to require those monies to be paid for this site. We're covered by our own development brief, which is the Inshes and Raigmore development brief, not the East Inverness development brief. And that brings to head how far, and this is the LSIC decision, is how far wider do you go? If you're out with a brief's geographical area, where do you stop? So I don't think the council has justified the relationship between this site and the costings in the brief. And we think the committee report simply doesn't go far enough to justify that, and there's no further evidence on it. I think that's where we stand on that.
I think you might be on mute.
Reporter, I think you're on mute.
I'm on mute this time. Mr. Gordon, anything that you would like to comment in relation to that? I know it's very technical in terms of the assessments, but in terms of the implications from your point of view?
Yes, as I said earlier on, there will be severe implications for us all. But the appellants again fail to recognise that today and through the public inquiry. And this is why you will find it difficult to make a decision.
Okay. Thank you. 3:10. Do we want to press on for the part C of matter 3, or would you like a break now? I have a feeling that the last two items on the agenda will get through quite quickly. I don't think there's much differences between parties, so it may take us half an hour or so to go through part C of matter 3. But I'm guided by you whether we do that now or whether we take a break and come back in 10 minutes.
10 minutes would be useful.
Okay. 20 past 3 for what should be the final session.
One of these guys, that guy there,
And she alone has to make a decision, is it?
Mhm.
She alone. Mm.
Okay, I think that's everybody back. Thank you. So this will hopefully be the last session of the hearing today. What I want to look at in item C is the potential need for developer contributions towards the Inshes Junction improvements project. Now, what Mr. Whelan said in his evidence previously was that the junction improvements and the wider infrastructure is all intertwined. But I would like to explore whether there's a need, if I decide that the contributions towards the wider infrastructure isn't justified. I also like to consider whether there would be a justification for seeking contributions towards the junction improvements project. So paragraph 2.4 of the appellant's hearing statement indicates that the appellant would accept Section 75 or other suitable legal agreement which would cover the cost of the no net detriment solution in relation to the Inshes Junction. And it is suggested that I consider the extent of works that both the council and the appellant would agree constitutes the no net detriment solution, which I think is something what Mr. Whelan was referring to previously as to what the cost. Mr. Pritchard, could you elaborate? I'm sort of not, I don't think I'm fully understanding what the appellant is meaning by that statement. In terms of if the council delivered the Inshes improvement project, would the appellant contribute the equivalent of what the no net detriment would cost? Was that the thinking behind it?
Yes, what we've always said, and we know it's not in the process at the moment of what that is. We've done it before, and as we've discussed earlier, our no net detriment solution was refused by the council, which is back in 2019. But if there is the or scenario of a no net detriment solution, we fully appreciate that the council don't want to do that, and they've not spent previous monies that we paid towards it. They're gathering those monies to do a larger proposal. So what we would be doing, and as I say, it's been done at the South Inshes Retail Park, is we would pay the equivalent monies towards the works that they want to do. So there is a definite methodology of calculation, and then that is given to the council. So I suppose the only difficulty we have in this process is it doesn't appear to me that we have an agreed no net detriment solution. So how you do that, I'm not sure. But perhaps if we get the figures from the council, and if they're using the same database as we're using as the traffic generation from the scheme, we at least have a basis to work from, and we have our original no net detriment solution that we've always lodged, and that could be the basis for the calculation of the monies or something of that ilk. That's all I was suggesting in that, because we know the council does not want any short-term measures to be done at the moment, and that's agreed.
Have you any indication have you done any costings of what you consider to be a no net detriment solution? I know that the council hasn't agreed that it is no net detriment, but I'm just wondering, is there a ballpark figure that you think
it was hundreds of thousands of pounds, but I think we did a calculation back in 2019 because that's when we were lodging that solution, and it was hundreds of thousands of pounds, a few hundred thousands of pounds. It was not anything more than that, and that was as I say, the basis for that was the 100,000 square feet, the 10,000 square metre consent that we got on the southern end of Inshes, which was for Dunelm and B&M, etc., was £100,000. It was significantly more than that, but it wasn't hugely more than that. And that's what we considered was the amount of monies that would be equivalent to the no net detriment solution.
Okay, so I had asked in my procedure notes 1st November, I think I'd asked the council to indicate what proportion of the overall contribution related specifically to the Inshes improvement project. And I don't think I got an answer to that, but it's maybe because from what you've said was that you've wrapped it all up into one. But on the evidence today, we're saying that the Inshes Junction improvement project is costing 8.5 million. So what would the council be able to work out what would be a reasonable contribution from the developer to that? Or what's the council's view on the developer suggestion about costing the no net detriment?
I think costing the no net detriment solution is the answer. But I don't believe what Phil was talking about, Mr. Pritchard was talking about in terms of his no net detriment solution was a solution that was accepted to the council. That was an application which was refused because it did not demonstrate no net detriment. So in terms of no net detriment solution, that is what we need to agree between the parties, and that refers right back to the start of our discussions about a direct access onto Culloden Road, and that being a condition of this consent moving forward to be delivered by the applicant. Costings of that were mentioned at 1.8 million plus land.
Okay, so that's where the council are at in terms of if going down that route. If you're just seeking contributions towards the Inshes Junction improvement, it's a similar amount, not quite, if the other one's up to 2.3 in current values, but we're still talking a lot more than a few hundred thousands of. You want to comment, Mr. Pritchett?
The council hasn't suggested within their costings what the value of land has been calculated at. So I don't know whether those are costs of construction or whether that is purchase of the land as well. So if the council can elaborate as to where their monies have been calculated from, because clearly there's a lot of land within Inshes within the appellant site, which the council require, whatever happens, and not just from us, but from other landowners as well. So I'm not sure where their calculations have got to on that.
Gary, are you able to give us a breakdown of what is in the 8.5, if that includes any land purchase costs or any CPO procedures?
We confirmed earlier on in the meeting that the land costs were not included in that.
If a land cost was valued, then, so I think which I'd referred to earlier, that potentially could come off the appellant's monetary contribution. So you would basically you would need to value the land, add it on to the total cost, and then that potentially would be deducted from what you consider the appellant's contribution to be. They wouldn't pay for the land twice. They couldn't pay a contribution towards the land and provide the land.
No, of course not. But in terms of his 8.5 million contribution, it won't just be the appellant's land, the other third-party lands that we'll need to acquire as well. So the total land cost plus the construction cost for the scheme, if you divided that, that's the true cost of the scheme. But in this case, the physical works on the applicant's land account to 1.8 million. And of course, they lose some of their land to deliver those works. So it'd be reasonable to put a value on the land and discount that from the 1.8. And Mark and Daddy can correct me if they disagree with that.
I don't need to get involved in the detail of that. It's just kind of trying to establish whether that's something that can happen, and the parties would be in terms of valuation and negotiation. If I consider that, I suppose it's picking up on what that a contribution towards the improvement project is justified. Mr. Smith.
Just very briefly, the Inshes and Rigmore development brief says any land required for the provision of Inshes Junction Phase 2 outline proposals, including flood alleviation or any subsequent iteration, shall be safeguarded for development secured by agreement using established valuation principles and dependent on the nature and intensity of use and development. That's talking about developer contribution. So that was already in the developer.
Can you give me
brief.
the page or paragraph number in the brief for that, just so I can find
It's
it?
page 30 in the development brief, I think. Talks about safeguarding and valuation principles used for the land agreement.
That's helpful. Thank you. Thank you. Is there anything more we need to discuss on that matter?
Can I just make one point in that I think we did discuss earlier about the differences between the brief, the original consent, and no net detriment. I think the hearing process should be aware we don't accept as the appellant that the mitigation of this site requires the full access from Culloden Road. We accept that's in the brief and that's what the council wants to see happen, but there is a difference between the wishes of the council to have that and the calculation of what the actual mitigation of this site is, a no net detriment solution. So we understand about the council saying how much that costs and what it is, but just for the avoidance of doubt, we don't accept that that is something. We think that gets into the betterment scenario, which you'll need to make a judgment on.
Can I just ask you, I suppose, almost full circle to where we were a few hours ago, Highland-wide LDP policy 7 talks about the proposal to expand Inshes Retail Park, provided the expansion helps deliver improvements in strategic road capacity. What's the views of the appellant in terms of does that justify the fact that strategic road improvements are needed as part of the proposal?
I think that's where the previous reporter grappled with that, and we've been grappling with that. And I think that's where I personally have a dilemma in terms of that is seeking betterment from an applicant to access their site. We've never said we're not going to contribute, significantly in this area. But what my concern is that we can't be seen to be, as it were, throwing money to obtain a consent, because as we've gone through the circular, any contributions require to be related in scale and kind to the development. So we fully understand what the development plan says. I think there's possibly a contradiction between what the development plan says and what we're legally meant to do in the development management process. I don't think there's an easy. There's a tension between those two things.
Mr. Whelan, does the council consider that the development requires the junction improvements?
The development requires junction improvements to access the Culloden Road. If they've been scaled to also serve the adjacent petrol station or additional access into the Tesco, if that's what Phil's referring to as betterment, we need to also think about that that is only 1.8 million, one arm of a wider scheme of improvements that's costing 8.5 million. But there's going to be amendments made to other parts of the whole corridor, which will be to the betterment of serving this development site as well.
You had your hand up as well. Is there anything else you want to say, or did I preempt your?
No, that was it. That
Right.
was it.
Oh well,
Thank you.
that's okay. That's I think I understand where parties are coming from. I'll sum up in the end where we go next. Mr. Gordon, would you like to say anything about that? That's specifically in relation to sort of the mitigating the impact on the junction improvements.
Yes, I would. Still, I reiterate what I'm saying earlier on and time again. How they're going to limit the mitigation to the properties and to the land surrounding it, not only to the site, but to the various projects and to the rest of the wider neighbourhood. Because again, I get back to the point. If this helps you, what I was going to state earlier on was some years ago, there was a figure of maybe 9,500 a day using the network. There's probably, as I said earlier on, 25,000, and potentially there will be more. So what I've heard this afternoon is, and before, this is where the difficulty was at the previous public inquiry, where there was a failure to come to a proper agreement to realise that the volumes will significantly increase and create more problems. And we are facing that still even at this stage tonight, and will in the future, if further development goes proceeding into this area.
Okay, thank you, Mr. Gordon. I mean, obviously we're focusing on kind of the transport impacts today, but I am aware that there are other impacts that I need to take into account when I'm assessing the proposal. So thank you for reminding me of that. That's helpful. Okay, I think we can leave matter 3. Transport witnesses can all breathe a sigh of relief. 2 more matters. I say I don't anticipate that they will take very long. The matter 4 related to the council's suggested condition on allotments. Excuse me. And I think the disagreement between parties is in terms of what happens to these allotments going forward. The council's initial condition suggested that they needed to be handed over to the council to be managed. The appellant has come back and suggested that the land should be leased to the Allotment Association, which would be in line with paragraph 5.1 of the council's allotments policy. I was just wanting to seek the views of the council in terms of that suggestion from the appellant as a way forward.
Can you just remind me what was the paragraph number within that document?
Paragraph 5.1.
I think it's a matter of principle. I think if there's allotments to be delivered on site, and it's a requirement of the development brief to have allotments on site, I view that as a community land use, and one which I would like to keep at a community land rate, if that makes sense. So, i.e., not for profit. If it were to be a long-term lease arrangement, I'm sure that could be agreed, providing there was a nominal value to that lease arrangement, as opposed to land transfer to the council, and you could have a long-term lease of say 100 years. I don't know if that would help the applicant in terms of their position or not.
I'll come back to Mr. Pritchard on that. Is there an allotment association in place? I suppose I was just thinking the practicalities of writing something like this into a condition, obviously replacing the wording that the council have. But is there an allotment association in place, or is it expected that one will be set up to use and run these allotments?
I'm not aware if it's a site by site basically project related group that's organised for each allotment site, or if it's governed by the council's wider association, if you like, of joint ones together. But we do have an allotments officer, so there's a matter I can take back to them to say, would you like it specifically named as the allotment association, or is there another name you prefer for that lease to be entered into with? I can definitely come back and confirm that, but long-term lease, I don't see an issue with that, providing it's a nominal value and it's not for profit for the applicant to make a return out of the allotments.
That's helpful, and maybe we'll ask you to clarify that depending on where we get to. Mr. Pritchard, had you given thought to what such leasing arrangements would mean? I mean, I don't know how much detail it needs to go into the condition, but obviously, if the council are concerned, what is long term? What were you envisaging whenever you suggested leasing arrangements rather than ownership?
No, to be honest, the view of the appellant was they do not want to sell land. They want to keep control of land for security purposes, operational purposes. It's part of a commercial development site. Absolutely understand what the council is saying. It needs to be viable for an allotment association. Certainly, the view of the appellant is we want to make the allotments work, and so therefore, of course, it would be at nominal value and a reasonable length of a lease that makes it viable for the allotment association. So I think we'd leave it to your expertise to draw up a reasonable condition based on that. It was just the point that the appellant will not be selling land there to any party, wants to control the land, but put reasonable leases in place for it to be an allotment for long term.
Well, certainly, I mean, Mr. Whelan, if you have, is there examples elsewhere that the council could draw on in terms of, I'm suspecting if that's the wording that's in the allotment policy, there may be other land applications that have had conditions written. Again, if that's something you could follow up in your closing submissions, and then the appellant can comment on that. I mean, I agree. It's about trying to find something that works, that allows the use that's intended in the plans to take to be implemented in the longer term. It doesn't necessarily matter to the wording of the policy with how it's done. So, but the council, the appellants obviously questioned your suggested wording, so I'll need to take a view on it one way or the other. So any help on that from parties will be welcome.
That's great. I'll take that away as an action to move that discussion forward with the allotments officer to see what our preference is. I know 10 years is noted in terms of a lease agreement in that document. I just had a quick search, but 10 years doesn't seem like a very long time to me in terms of long-term lease. So I'll
okay, that would be helpful.
Thanks.
Are there any other matters anybody wants to bring up in terms of the wording of that condition? I think that was the only thing that the appellant was struggling with. Okay, if that's, we'll move on to the final item, which I don't think there's any disagreement on. I'd raised the question about the duration of permission, because changes to the Town and Country Plan Scotland Act had changed the fact that I need to put a condition on in terms of the duration of permission if planning permission is granted. The appellant had no comments, and the council said a maximum of 5 years. I mean, 5 years would be the standard. I just put it on the agenda in case any of you wanted to add to what you'd said otherwise, but if you don't, I don't need any further evidence on that. Mr. Whelan?
Yeah, it's just to make sure that if you are minded to grant permission, that it is then time limited to 5 years, and it depends on what conditions you choose to include within the permission. If an updated retail impact assessment, for example, would be required again, as it did with the first condition of the last appeal. It's just to make sure that the decision made is current and reflects the baseline position, which may well change in the future.
Okay. Thank you. So that completes our discussion on the specified matters. You'll all be delighted to know. Thank you very much for your evidence today. This will be taken into account alongside all the other submitted written evidence in my determination of the appeal. As I indicated at the start, I'll give you the opportunity to submit the equivalent of a closing submission, summarising your views on the matters discussed. And we have a few specific points where I've asked you to address. As is customary, the appellant would have the final word. So in terms of timescales, I was going to suggest that the council and Mr. Gordon would have 2 weeks from the 4th of January. I'll give you Christmas off. You'll be glad to know. So from the 4th of January, that would be the 18th of January for the council and Mr. Gordon to respond, and then the appellant would have a further 2 weeks. So that would take us to the 1st of February. Now, I think what would probably be most helpful is if I wait until I get those closing submissions before I take a view on whether I need further evidence in relation to the transport impact and modelling. I don't want to second guess what you're saying. I think that would allow parties to address their thoughts on that. Give me your suggestions, and then I'll take a view. Do those timescales sound okay for parties?
I would like to request an additional week if that's possible. And part of the reason for that is we have currently received matter specified in condition application from the appellant on implementing the original appeal decision. I'd like to make sure that we have undertaken our work on that first and foremost before responding, if that makes sense.
I mean, obviously what's happening with the existing permission doesn't affect what the outcome of this appeal. I can't get involved in that, nor do I want to. I suppose just for context, at the same time, I will be issuing a further procedure notice seeking views of all parties on MPF 4 as well. It's National Planning Framework 4, Mr. Gordon, which is currently before Parliament, and I suppose may well be approved by the time we get into January. I was proposing to kind of run those two in tandem, so not to cause unnecessary delay, but I realise it will put extra work onto the council as well. If I give 3 weeks, that would be on the understanding that you could manage the MPF 4 one at the same time.
Yeah, I think that's fine.
Is that a yes? A yes from the council?
Yeah, well, why not?
Mr. Pritchett, do you have a view on that?
I'm not going to argue. We just want to get to the end of this process as fast as possible.
It's 2 weeks. It's 2 weeks after the council's date. Okay for you?
Yes. Yes.
So that would be the 25th of January for the council, and Mr. Gordon, if you want to put anything else in writing, you don't have to. It's up to yourself. And then the 8th of February for the appellant. And say following that, I will try and turn around as quickly as possible whether I feel we need further procedure. So you can give me your views on that. the alternative is that I determine the appeal on the basis of the information before me, and that's the, you know, we draw a line, and I use the information I have. Obviously, with those steps, it means that the period for determination of the appeal will exceed its target date. I was due to get that out on the 4th of January. As I say, I'll aim to issue the decision as soon as I can, and I'll provide a revised target for the timescale when I can. I'll possibly do it on the. I'll consider the target on the basis that I am going to need further procedure, and therefore, if I don't, it'll be shorter. I think it's better that than setting an unrealistic and then having to extend it further. Any further questions from anybody about today or what the next steps are? Mr. Gordon, are you comfortable with the understand worse?
Yeah, I understand all that fully. I will just probably rely on you considering the evidence I've given today, but I expected to have been fully more informed than I was. Or should I say, been more cross-examined than I was. So I'll rely on what I've provided here today.
No, that's been helpful. I mean, a hearing doesn't involve cross-examination. It's very much just about people providing the evidence that they wish, and your input has been welcomed and valuable. Thank you.
Well, just further to that, sorry. Obviously, I would have liked to have given, if I had been able to give more of an opportunity, obviously other parties, I do accept that they've taken more of your time and they've been given more of a platform. So I would have valued it if I had more of a platform.
Okay, I'll take that on board. I think that the fact is that the focus of the hearing is about the information that I need further evidence on. So it's not to belittle any of the other matters that I need to take into consideration, but there were some very specific points in relation to the conditions and developer contributions that I needed to understand, which is why we had to spend the time on that. But I say the evidence that you've already submitted in writing and your contribution today will all be taken account in my consideration.
Yeah, I accept that that a judgment is not forthcoming today or tonight, should I say. What I'm trying to say is, obviously the professionals have been given a wide platform today, but as a layperson on behalf of the community, again, I'm aware of a lot of what's involved, and what I will draw with conclusions is that everybody within the community at large realises that this is obviously going to have severe implications to them, not only to me at large, but everybody else. So what I'm suggesting is that if we face this situation again, that the lay people will get a more opportunity set aside onto an agenda or a platform, as I call it.
Okay, we'll take that on board. I mean, just to reassure you, everybody that submitted comments on matters that we were discussing today were invited to take part in the way that you chose to. But other parties decided to rely on their written submissions. But I have all that information in front of me. But I take the points that you make and say thank you for your contribution. Mr. Whelan?
Yeah, I'm trying to remember what I was going to say now. Yes, MPF4 and adoption. I think it slipped off the agenda for Parliament in January. So, on the basis of our follow-up submissions, it'll be based on the revised draft version. Presumably, the timescale for the adoption of MPF4 will that have an effect on proceedings or not?
Yeah, what I'll do is that when I issue that further procedure notice, I'll obviously reflect the position that MPF4 is at that time. I mean, it may be approved in January. I think there's then potentially be a later date for adoption. Obviously, if it's not approved and a decision's made not to approve it, then we'll reflect where it's at. So it is a bit of a moving feast, but it's such an important consideration that I want to give parties the opportunity to let me know what they consider the implications are for the proposal. Okay, well, we're just about before 4 o'clock, so I failed miserably in terms of my 3 to 4 hours. Sorry for that, but it's certainly been very worthwhile from my point of view in terms of aiding my understanding and consideration of the matters. So I thank you all for your input today, and hope you all have a good Christmas.